when he mentioned. Yes.
I am for the petitioner, Lordship.
I got the CSO.
Lordship, the
But I appear for
petitioner's
the
case is that
private
petitioner
respondent.
has
Respondent number
purchased one property, Lordship. Petitioner has mutated in the Kolkata Municipal Corporation records. Tax bill petitioner is paying. Applied for a construction connection. The land is vacant, Lordship. Petitioner intends to carry on a construction. For that, applied before the CSC
Because
authority.
affidavits have already been directed by an earlier order. Now there is no interim order that they're enjoying. I am the respondent number 4.
There is no interim order.
I have served them the copy of the opposition last year. May I file the opposition? There is no reply used by them.
Lordship,
There was a solemn order on 18th September
Yes, yes,
2025.
Ah.
Honorable Justice Kaushik.
It is not in the
What is the
motion.
matter? New connection.
Lordship, may I submit?
I'll just
Lordship?
tell.
Lordship,
It is the difficulty is I am the owner of the same property from 2005. The same property is purchased by the petitioner today, and he claims to be the owner. I go ahead and file a civil suit, say declaration that I am the owner, don't disturb my possession. I am enjoying the interim order, he is a party to the civil suit. From June last year, they don't disturb my possession. That injunction is there. Now mutation is my name for last 10 years. Now he files a petition by saying the CAC is not giving him connection. I say that.
How do you say that you are in possession?
Lordship, may I
There is
submit?
an interim order in favor of the private respondent saying that you should not disturb his possession. That prima facie
Lordship-
shows he is in possession.
Lordship, kindly sees Annexure P1 once.
P1 is what?
Of the writ petition, Lordship.
Page.
Page 10.
Yes.
This is the bill issued by the Kolkata Municipal Corporation. The premises number is 984 by A by 4, Kalikapur Road. It is recorded in my name, Lordship. Thereafter, we have applied before the CSC authority. CSC authorities went for inspection, found us in possession. They have issued the quotation in our name, Lordship. Kindly see page 11, the next page. They have issued the quotation of 88,784 that we have deposited. CSC authorities went for installation of the connection. Private respondents objected. Thereafter, the private respondents have given a letter of objection before the CSC authorities that I have annexed, Lordship. Kindly comes to page 14 of the writ petition. Lordship is on page 14. Lordship, the first paragraph in the middle. Tozi number 2998, PS Gorfa, having premises number 984 by A by 5, Kalikapur Road. Their complaint is on 984 by A by 5, Kalikapur Road. Now, Lordship, kindly comes to page 11, page 10 again, Lordship. My premises number is recorded by Kolkata Municipal Corporation 984 by A by 4, and they have made complaint on 984 by A by 5. Now, Lordship, they have stated that there is injunction order on the said premises. Now, Lordship, I am with the judgment passed by Justice Bakshi, Lordship.
That is in a different set of facts. If there is an order of status quo, good. That will not prevent the electricity authorities from affecting electricity supply. But you have to prima facie show that you are in possession. If there is an injunction order asking you not to disturb his possession, that prima facie shows he is in possession.
Yes, the difficulty is there has to be a demarcation. KMC must be made a party here. Because I say the premises.
There was a direction for affidavits exchange.
Yes, there is a direction for affidavit. I have specifically given my conveyance and I have said that there is
your affidavit in reply to
No.
this?
Lordship, I have not made ready the reply, Lordship.
Make it, because I cannot pass an order which will lead to a final order being passed from the writ petition. Because if I grant connection now, that will amount to disposal of the writ petition, which you did not get at the interim stage.
Lordship.
But I say that KMC should be made a party here, which is subject to the obviously the petitioner's prerogative.
Lordship,
but without
that will create a title dispute, Lordship.
Without the KMC
affidavit in
his
opposition
prerogative.
filed on behalf of
Item number two, I'm appearing for respondent number 6 and 7. I'm being led by Mr. Rachit Lakmani. He's appearing online, Your Lordship.
Yes.
Lord, this is, my Lord,
My lord, this,
my Lord, this is that matter where the parties had reached a settlement.
Yes.
And my Lord, my learned friend in court, my Lord, is carrying, my Lord, the draft order for your Lordship's consideration. If that may be handed over.
It can't be proposed
It and
consent order. You have to give me the terms of your settlement. You can't propose an order to court.
my lord, this has been given to me by
Sorry, my lord.
WhatsApp to me, and the fact is that there are some mistakes and some problems in calculations.
Mr. Lakmani, please, both of you, file an application bringing on record or whatever you say to be your consent terms, that I will record in the order. You cannot propose an order to court like this.
My lord, Lavani Estate also telephoned me that there is an outstanding dues in respect of their maintenance also.
Yes, Mr. Lakmani.
The marathon from the other building. Consent. So, my Lord, we've sent it to them. Last night I had a word with my learned friends.
Yes, my lord, there is some mistakes in the calculation made by him, and as your lordship directs.
Both of you are agreeable to some terms, then you inform the court about the terms. I'll make that a part of the order and I'll pass an order accordingly.
As your lordship directs.
Tell me when can you come back?
5 days maximum.
Next week, anytime.
Next week.
After a week?
After a week.
And my Lord, just one more thing, my Lord. Consent order by consent. We sought the
Consent order you cannot, you don't propose an order to court. Order has to be by the court.
Very
You
well.
have to give me the consent of both the parties agreeing to certain terms.
that your Lordship will get.
That if you give the terms, I'll incorporate that in my order.
Yes.
You cannot propose the order.
You know, understandable, of course. Of course. Very well.
I don't follow that practice of proposed orders. No.
No
If you
difficulty.
give me the terms, I will, if both of you are agreeable, I don't have a problem.
Yes, my Lord.
I'll incorporate that in the terms. That will go down as your terms, as
Yes.
agreed terms, and the order will be on consent of both the parties.
No
So
difficulty.
both of you, please come to terms, whatever terms it is, and make the court aware of the terms that you have agreed upon.
As your
No
lordship
difficulty, my
directs.
Lord. No difficulty.
Both the, I'm recording this, that learned advocates appearing for both the parties Yes. Yes, madam.
And the petitioner, my lord. The petitioner undertakes to participate the mediation proceeding in a good faith and comply with a reasonable direction for the High Court. The earlier location has passed an order. No notice for Lok Adalat has been issued for upon.
What are you challenging, madam? Madam, what are you challenging?
Participate in the mediation proceeding in a
Mediation,
good
if
faith
both
and
of you
comply with.
can agree, I will send to mediation. I don't have a problem, but I can't.
Essentially, my learned friend has challenged the sale under surface action. And
You go before the DRT, madam. Challenge it
they
before
have
the DRT.
clearly challenged that because essay is pending.
It's
Really,
spent-
DRT matter to secondary.
That application was prepared by the son of the petitioner Victoria for the same property.
Yes, madam. If you have already challenged it, don't come here.
And property has already been sold, my lord.
Sold also.
That was disclosed before the learned DRT as well.
So what is the challenge here?
Not I. As such, my lord, there is
Settlement of loan.
Yeah.
She wants up-to-date statements to be made over to her.
that I'll provide. But property has already been sold. That was communicated to
But
the
she
land.
has not challenged the sale here.
Yes, my lord, but
Interest, creating third-party interest. Yes.
yes. Prayer E, my lord.
Hmm?
Prayer E.
That is interim order.
Yes, my lord. That he has asked for.
लिखे नहीं. This writ petition
Item number 4, my lord, I'm for the petitioner, my lord.
But I am for the respondent.
The petitioner grievance is, my lord, petitioner is the, my lord, owner and occupier of some plots of land. In 2008, my lord, ignoring their objection, my lord, some poles, my lord, 8 poles were installed, my lord, in the land, and 1 transformer was set up in the said pole. My lord, the objection was raised, my lord, that was not, my lord, adhered to. My lord, the suit was filed before the appropriate civil court. My lord, that suit was decreed on, my lord, 25th March 2014. My lord, against that decree, my lord, the distribution company preferred an appeal. First appeal, my lord, before the appeal forum. My lord, that was also, my lord, partly allowed, my lord, with a direction to remove those poles within 1 month. My lord, that was not, my lord, complied with. In the meantime, my lord, the petitioner, my lord, filed an execution proceedings. While execution proceedings were, my lord, going on, my lord, they preferred a second appeal before this honorable court. My lord, this second appeal also dismissed on 14th September 2023. My lord, after dismissal of the second appeal, my lord, they removed, my lord, 6 poles out of 8. My lord, they removed 6 poles, my lord, lying in the land of the petitioners. And apart from that, my lord, their 2 poles are still lying and transformer is removed. My lord, the 2 poles are still lying, and my lord, removed poles also in my land. My lord, petitioners, my lord, approached the, my lord, authorities, my lord. In the meantime, what happened, my lord? A so-called was issued to the, my lord, the defendant, my lord, why the, my lord, the civil prisons order ought not be issued against them for violations of the court's order. My lord, after receiving that so-called, they appeared before the court below an executing court, and my lord, the submitted so-called with a statement they have complied with. On the basis of that, my lord, the learned executing court.
Why did you not say before the executing court that they have not complied with the
My lord,
Execution was disposed of having
on
satisfaction.
the same day, they were recording, my lord, they are so-called,
It
and my lord,
Chaudhary, if
yes,
the-
yes, my lord, I know, my lord, the second execution is maintainable, my lord, this 2008, my lord, the petitioner, my lord, running, my lord, pillar to post, my lord, execution, my lord knows, my
Well,
lord.
we have complied.
But-
We have removed the transformer. We have
Yes, my lord, 2 poles
removed the
still lying, my lord,
poles.
2 poles.
These 2 poles are
No,
still-
now my learned space content says these 2 poles also upon his lands. But my station manager's milord says that it is on the just side of the road. So let there be an inspection by the BLLRO. If it is upon his land, milord, naturally,
That
because
was, my lord,
the lower court as having satisfaction drop the proceedings of execution.
the only-
Your lordship kindly consider.
Mr. Chaudhary, if the proceedings have been dropped, execution proceeding has been dropped upon
Having
discharge-
satisfaction.
upon satisfaction of the decree and the execution.
my
has
lord,
been
I, my lord,
discharged,
they fully complied with not the, my lord, the order, my lord, they are aware, my lord, my
where is the executing court's order?
my lord, the last, my lord, page 69 is the order, my lord.
More than 100 families are getting electricity connection from that line.
Up to the, my lord, second appeal, my lord, they have loose, my lord.
Mr. Chaudhary, please read page 69. How can you say that? Please read page 69, just the paragraph after the expression considered.
Yes.
Please read this. It is observed by this court.
That's that is the object wrong.
Mr. Chaudhary, how will the writ court go into this if the
Well,
civil
that's
court
it.
has observed this? Kindly see this. See the
Yes,
observation.
my lord, the compliance, my lord, they have recorded.
Voluntarily in open court submitted that judgment debtors have removed the electric poles and the transformer from the
Yes.
suit property and have also filed an affidavit in this regard.
Yes, yes, my lord, that affidavit I have annexed, my lord.
Kindly see the ordering portion is dropped on contest.
Yes.
Yes, my lord, that.
If you say that there is a fresh and again see, any new cause of action stated by decree holder cannot be considered in the execution case. If you have a new cause of action, then you can be directed to approach the district magistrate concerned.
My lord, the after disposal of the, my lord, execution proceedings, fresh, my lord, I have made a representation, my lord, next page, my lord, there I have already agitated, my lord, 2 poles are, my lord, still lying.
Very well. I am sending you to the district magistrate. District magistrate will conduct inquiry.
Yes,
if he
yes,
finds
yes,
that
yes.
it is on your land in terms of rule 3 of the works of licenses.
We have no difficulties. We have no difficulties. But my lord, kindly observe that this lower court has already having satisfied.
I will observe what is
Fine.
on record.
I'm
appearing on behalf of the respondent municipality. This is a matter relating to municipality unauthorized construction.
Don't have jurisdiction.
My lord, I am for the municipality, my lord. This,
Lick in it.
honor
Uh,
of the municipality, my lord.
Let this matter go out of list for lack of determination. But why has WBSCDCL been made a party?
But Lordship, this is Chairman Boidobati municipality and others.
No.
Probhati Shaha and another. Item number
কি
5.
কি দিয়েছেন এটা? নাম ভুলভাল দিয়েছেন। আপনি আমায় ফাইল অন্য দিচ্ছেন, ইয়েতে নাম অন্য দেয়া আছে, কেন এরকম হচ্ছে কেন? It is wrongly appearing. It will not be here.
Yes, my lord. My lord,
There is a mistake in the list. Not a
my
problem.
lord, my.
Yes, কিছু করতে হবে। Not today. Next.
Take time for the state lordship.
I will seek time for the petitioner, my lord.
এটা কোনটা?
6.
6 time for the state lordship.
তোমার ইনস্ট্রাকশন আছে কিছু?
থানার আছে, এমনি তো কোনো না, WB ACDCL
কি বলছে থানা?
সিভিল ডিসপিউট
হ্যাঁ,
ACDCL দাঁড়িয়েছো?
আমি আছি। আর আমি আজকে ইনস্ট্রাকশন পাবো তারপর।
Petitioner filed the petition for inaction of the
My lord, item 3.
respondent, my lord. But
Before my lord,
the respondent
up
also,
now, I have received instructions to represent. I have not yet received the copy of writ petition that has been sent to me over my mail.
This week, let him
So
come with instruction.
I'll have to take instructions because he is asking for shifting the line from the private respondents getting electricity. So my lord, proper instruction has to be needed. Otherwise,
Mr. Kole, learned advocate appearing for the WBSCDCL authorities.
I am for the petitioner.
for the distribution company.
Lordship, this submersible pump connection application, Lordship, applied in the
Mr. Shukla, what is the
year
problem?
2023 application made.
In 23 applied, in 24 inspection was made. At the time of inspection, there was
Meter board was,
neither the
meter room
meter
was
room
not ready.
nor the pump was
Everything is
installed, nor there was boring.
Lordship, the Lordship has passed certain direction, Lordship, I am taking same order.
We issued a letter to them, asking them to intimate us whenever it is complete.
Lordship,
They did
we will intimate them within 1 week.
not intimate us. We issued a memo to
They
them
will
in
intimate you once
28/12/24. We are
they
ready.
intimate you if you
If
find
they
that
complete.
they will intimate you if you find it is complete, then
Yes, my
lick in
lord.
it.
9th of December. 9th of December.
Mr.
Eight Lordship, I am for the petition.
Sir, I am praying for not today, my lord, only as because Mr. Devjit Bhai went for doctors.
Not today.
Sir, only
not today.
only not today, my lord.
Next.
My lord, मेरे पास similar order as in item number 7, similar case, same similar instruction.
ওই আইটেম 7 এ যে অর্ডারটা হয়েছিল
Please, Your Lordship, my lord, this is my application. I must indicate I am led by Mr. Mitra. May I start, my lord? The issue involved, my lord, with respect, my lord, is that bank has entered into a contract whereby the loan accounts of two companies, the writ petition number 1 and writ petition number 3, were agreed to be settled. And the amount of settlement was distinct for both the companies, the writ petition number 1 and 3. Now, my lord, the amount that was required to be paid by writ petition number 3 within a truncated period of time was paid. Insofar as writ petition number 1 is concerned, there was delay, and bank has accordingly extended the time. This was the third extension whereby I paid the entire amount, including the delayed interest, and the entire amount has been received by the bank without any demur. My lord, after receiving the amount, where time was not an essence insofar as the last extension was concerned, bank came up with another demand and resiled from its earlier stand by saying that I want compound interest. My lord, after the contract was acted upon and concluded. This is the cause, my lord, that there are two limbs of the submission in this case, my lord, that insofar as writ petition number 3 is concerned, the amount was duly paid. I'm entitled to no due certificate and I'm entitled to return of the title deeds, which they have not done. And 2, insofar as the settlement payable by writ petition number 2 is concerned, in the extended period, it was paid. Now, my lord, they are stopped from demanding any further, which they have demanded. Hence, my lord, the writ petition. The urgency involved is that after all of this, they have taken an action, my lord, contrary to the contract, and now contemplating to sell the very two assets which they were liable to return by way of redemption. My lord, that is the cause before my lord in this instant application. If I may request my lord to kindly consider the settlement letter which is appearing at page number 85.
Page?
85.
85, yes.
85, my lord. This is marked as exhibit annexure P8.
Yes.
My lord, kindly consider that there are two companies addressed. One has 12 crores payable by Sri Madhav Edible Products, which is writ petition number 1. And Madhav Solvex Strex Limited, 52 lakhs, writ petition number 3. Cumulative 12 crores, 52 lakhs. My lord, insofar as writ petition number 3 is concerned, may I address and complete that issue first? My lord, kindly consider that the entire amount to the extent of rupees 52 lakh was paid. My lord, may kindly consider page number 92. This is my leisure, but I have documents to support that.
Page 92.
92. My lord, this money was required to be paid on or before 15th of March 2019. My lord, will consider that in 3 installments, entire 52 lakh was paid.
Yes.
And my lord, the money was paid, the proof of payment, insofar as 2,80,000 is concerned, is at page 89.
Page 89.
89, my lord.
Page 89 is what?
Is my mail whereby I have paid the upfront amount towards, my lord, writ petitioner number 3's company. 2,89,000. My lord, next page 88. I'm showing, my lord, the payments been made as detailed in page 92. This is my leisure, but I have other corroborative evidences, my lord. Kindly consider this is the mail which says, please find attached here with the receipts of upfront payment of Sri Madhav Solvextrix Private Limited, repeat number 3. And my lord, page 88 is the proof. They have received it. Page 89, my lord, it is another amount of 2,40,000, which is again paid from the account of writ petition number 3 maintained with Corporation Bank. My lord, this is just at the middle. The credit entries, my lord, will find 2,40,000. And my lord, lastly, if my lord considers page 90.
Yes.
This is the email whereby I have paid 46,80,000 to the bank, admitted position on account of Sri Madhav Solvextrix Private Limited.
So 52 lakh paid.
Paid. Now, my lord, once 52 lakh is paid, they are liable to return the title deeds and no due certificate insofar as this account is concerned, which was guided by a separate jural relationship. Well, there is a separate sanction.
Mr. Mishra, prima facie doesn't appear to be so because they have treated this to be one contract. The amount which was to be paid was 12.52 within a particular time. So we cannot segregate that. The letter shows that settlement amount is 12.52. It doesn't say that there are two contracts. One will be 0.52, one will be 12. So I will not agree to
My lord,
that.
may in order to satisfy my lord, this
Prima
point
facie doesn't appear. If you see page 85, I was just noting that page 85, it doesn't say two. You see the terms and conditions. The first term itself says settlement amount of 12.52 crore. It doesn't say settlement amounts of 12 crore in respect of one and 52 lakh in respect of others.
two respectable, my lord, response to satisfy, my lord. My lord, there are documents to substantiate it. One, kindly consider the table.
Yes.
It splits into two different accounts.
Yes,
one
but
for
it reaches a total also.
Summation is that. Why?
It was
Because
not required. If prima facie, of course,
my lord,
I am opening my mind so that I can get an answer.
yeah, my lord, kindly.
If it was in respect of two separate entities and that is how the contract was understood to have been entered into, then in that case, they would not have gone to make an aggregate. They would have stopped at 12, they would have stopped at 0.52 and would have said that upon payment of 12, you will be entitled to remain entitled to the title deeds being released, and upon payment of 0.52 lakh, the crore, the other person will also be entitled to get release of the title deeds.
My lord.
But that apparently does not appear to be the term of the
My lord, what has fallen from my lord very respectfully on fact is absolutely correct. I will not join issues. But in law, this cannot be conceived. Why? Because, my lord, insofar as writ petition number 1, where 12 crore was the amount, there is a special contract, special sanction. And
Mr. Mishra, it may be a special contract, special sanction, but when you enter into a compromise, taking both entities together being represented by the same parties, then in that case, it may have I understand the company being a separate juristic entity, having a separate mantle, different personality, all this is there. But all of them are being controlled by the same person who represents to the bank, saying, because I see the names of the directors also.
Yes, my lord, that I must admit.
So the same, it's all being tethered to the same core. The core is same. The bank has understood the contract in a particular way. If you can show that you understood it in a different way and you make your understanding, you conveyed your understanding of the contract to the bank in the way you understood it, and the bank accepted that, that can be a different.
Kindly consider page 103 and page 111.
Yes.
This is a letter whereby I was seeking extension of writ petitioner number 1 settlement amount, where I clearly mentioned that insofar as writ petition number 3 is concerned, which is table middle entry, it is nil. I have paid no rebuttal from the bank. Number 2, my lord, page 111, if my lord may kindly consider with respect, my lord. 111. This is another letter whereby I had sought for extension, which I was repeatedly doing sporadically.
But then Mr. Mishra, with all your letters, have you said that since the settlement in respect of the second entity here has been reached. Therefore, kindly release the title. deeds
Yes,
in
not
respect of
once,
that.
my lord, 7 letters.
No, in 18 July 2020 letter, you have written that.
My lord,
If
not,
that was your understanding, you are entitled to get it only.
my lord,
then.
may I show, my lord, what is fallen from, my lord? May I show exhibits? My lord, will first see page 111. 29th April 2024, notice, representation.
No.
And
this
my lord,
comes-
I'm coming to that, my lord. What is fallen from, my lord? I have understood. I'll show that. My lord, may I only place respectfully page 111, fifth line. In the middle starts with the word we wish to place. We wish to place the fact before the bank that entire principal amount in case of Sri Madhav Sole, writ petition number 3. And my lord will kindly ignore the another name which was not the contentious issue. And Sri Madhav such and such has been paid, no rebuttal. Now, my lord, second point, my lord is looking into that whether I have demanded the money, the title deeds. My lord may kindly consider a repeated request made to the bank My lord may kindly permit me to place page. Sorry, my lord. Which page? My lord may kindly consider page number 123. Where I have also paid the writ petitioner number 1 settlement, which was guided by another exhibit, my lord, another document. I'll place that also. And my lord, henceforth, I am writing to the bank that please return my documents. Please return my title documents. Please issue.
When was this extended?
My lord, that my lord will find at my lord page 119.
119. Yes.
Page 119. Mail, my lord, by the bank from Circle Shastra, Kolkata. That is the bank's recovery. My lord is aware of it. Circle office operates for the purpose of recovery. And this is on June 28, 2024, whereby, my lord, they extend the period of payment. The only, my lord, demur which I will attach to this is that despite having received the entire OTS amount within the time for writ petition number 3, the bank on its own volition, my lord, even kept a portion of respondent number 3's account payable, which they cannot do. Because, my lord, when I'm paying the bank with an instruction, my lord is aware of section 59 of the Contract Act. I am expressly saying that you will adjust it there. Bank in its own fancies, my lord, has segregated and kept a portion of petition number 3 OTS amount due, which they submit here. My lord, can you take page 120? There is a table. This is the contract whereby they say that extension is given to you. And I have acted upon. My lord, may kindly see, my lord, there are two tables, one on the left and one on the right. Insofar as left is concerned, there is writ petition number 1. And right, writ petition number 3. My lord has seen that I have paid entire 52 lakhs, yet they kept 3 lakh due here. And insofar as, my lord, writ petition number 1, they say, my lord, 2 crore 8 lakh 84,000 as the extended OTS amount. Rest all I have paid. This was the residue with delayed interest. And they sum it up to 5 crore 15 lakh 16,000. And this also I paid. Not only this much, my lord, I paid 5 crore 68 lakhs inadvertently because 20 lakh was lying in the no-lien account. I'm not joining demur, my lord. Insofar as I have to pay, that has extra gone to them. I'm on the point, my lord, after having received all of this, bank came up with another demand. And now let's kindly see how cryptic this possibly is. Well, I'm aggrieved on this particular. Kindly consider page 152. one-liner, and this is because their competent authority, no reason, no finding. And my lord has seen that mail of which is the extended contract of June 2024. Time was not an essence. It never contemplated. But I have paid, they have received no objection raised. In page 152, they say total compounded interest to be paid is 1 crore 81, additional demand, after having received the entire OTS amount without any objection. Now they want 1 crore 81 lakhs extra. Is the place, my lord, I am aggrieved. And my lord, they don't stop here. My lord, my letters, all of those letters which says that return my title deeds, I have paid the entire amount. Please issue a new due certificate. The contract is acted upon. The bank proceeds not to reply to any of those letters. The only letter that came was with an additional compounded demand of 1 crore and 18. And followed by, my lord, page number 153. My lord, this I would rather understand it arbitrary, my lord. My lord, other surfacey causes, I will not trouble the writ court, my lord. I will go to the DRT. But this is a contract which has been violated by them. My constitutional rights have been taken away. The entire debt is repaid. Now, my lord, kindly see page 153. They contemplate to sell both the properties again of writ petition number 1, which is property number 1, and also of 3.
Yes, Ms. Sinha.
Lordship, first of all, I would draw your kind attention to page number 111, as has been pointed out. Though I have not received written instructions in this matter, but prima facie, what falls, there is an appellate authority, the DRAT. He has a remedy over there. And page 111, your lordship. At the outset, whatever had fallen from your lordship, it was also my basic interpretation. But now your lordship kindly sees the language. We wish to inform you that an amount of 289,63,804 is principal balance payable after making payments as per the settlement. The above amount is total due principal amount in all the 3 accounts. He is himself admitting that these are 3 amounts payable: Sri Madhav Rice Mill and Sri Madhav Edible Products. We wish to place the fact before the bank that entire principal amount in case of Sri Madhav Solvay Tracts and Sri Madhav Rice Mill has been paid. Further, the bank has also adjusted the amount of rupees 20 lakhs, which was deposited as upfront amount and was to be placed in no lien account. Amount of 289,63,804 is the principal amount outstanding after adjustment of rupees to 20 lakhs. We have firm commitments from our relatives and business associates who have agreed to lend us amount to enable us to pay the amount to the bank.
Mr. Mishra, why don't you go to the DRT again?
Yes, this.
Or paragraph number 20.
It is not something that cannot be addressed by the DRT.
My lord, this possibly, kindly consider para 20 and consider section 17, subsection 1. This, what is impugned, my lord, is not a 13-4 action.
8-6 is a 13-4 action.
Yes.
8-6 is a 13. My lord, that's a consequence of the inaction, omission on the part. I am on that
Mr. Mishra, the immediate cause for your writ petition is the 8-6 notice. Before that, you had not come. Now, therefore, the immediate cause is that. Now, the 8-6 notice is definitely premised on certain factors. Once the DRT is in season of the 8-6 notice, whether it has been rightly issued or wrongly issued, it will have jurisdiction to address this also. It can't be said that the DRT cannot address this. In any case, in any matter which you take to the DRT, the DRT gets jurisdiction to travel behind the action. The action impugned is one of either taking possession, or putting up a property for sale. Now, the action of taking possession is challenged very many times, more often than not, on the ground that there is no loan. The account has not become, has been wrongly classified as a non-performing asset. It is not a non-performing asset at all. All these things can be gone into by the DRT. Similarly, this aspect also, whether the loan has been squared off in terms of the agreement reached by the parties or not. What is a settlement? A settlement is to pay something which is lesser than the earlier sum, which was due.
Sacrifice.
It still remains and retains the character of a loan. It does not become something else. It's
My lord.
still a loan that you are repaying.
My
Now, the loan amount has been toned down by consent of the parties from X to X minus X or X minus Y,
My lord.
whatever it is. That can be addressed by the DRT in a manner in which earlier challenges have been resolved by the DRT. So why don't you
Three
approach there?
respectful submission, my lord.
Because I could have understood, Mr. Mishra, if this was an act wholly without jurisdiction. I can understand. There are certain ways in which it can be interpreted. One of the interpretations may be correct, bank may be wholly wrong, but it will not knock the bank's jurisdiction off. It cannot knock the bottom of the bank's jurisdiction itself. The jurisdiction remains. It is an error within jurisdiction. It is not an action wholly without jurisdiction.
Inherent lack of jurisdiction, lack of jurisdiction. It may not be inherent lack.
It is not even lack of jurisdiction. It is an error within jurisdiction.
No, my
The
lord.
bank has acted wrongly. If I assume your arguments to be absolutely correct, take it absolutely on face value, and then also proceed. What will be the conclusion that I draw? That the bank did not have jurisdiction? No. I will say that the bank has acted wrongly in doing this. Now, this is exactly what the DRT is going to say. I would have the discretion only if you could show that it falls within one of those limited exceptions, and much more when it comes to SARFAESI action after several judgments.
I'm aware of that, my lord.
Coming on this, and most often than not, the one-page judgment which we used to cite, that ICICI Bank Mahapatra, Umakanto Mahapatra judgment 2019, where the one line which used to be our punch line while we were on that side, that it is not maintainable. That is the line.
Went through Kerala High Court and it went finally to Supreme Court. My lord, but my lord, may I only say this?
Mr.
My lord, kindly consider, my lord.
I'll direct the DRT to take it expeditiously, dispose of expeditiously, because all of this will unnecessarily entail time, and maybe you will land up with a dismissal up somewhere. So instead of that, let me relegate you to the DRT with all directions, saying that no, it will be adjudicated prior to the time when your sale is going to be put up. That I can say.
My lord, may I, my lord, before my lord dictates the order, my lord, I have understood what is running through my lord's mind. But my lord, I generally, my lord, do not trouble the honorable court, high court in constitutional writ jurisdiction with these matters. It's exceptional circumstances in which I have come. And my lord, this falls within the exception, my lord, respectfully, if I may make this submission. Why? Now, my lord, if this is allowed, then SARFAESI Act and action taken under SARFAESI Act is colorable exercise. After all of this, if SARFAESI action is the action taken and I have to be relegated to DRT, my lord, this is absolute abuse of process of law. And I say the bank lacks jurisdiction essentially because, my lord, to demonstrate after showing the exhibits that there is no debt payable. That is the place, my lord, may kindly come to a finding that there is no debt payable and it is the secured debt for which SARFAESI action is to be taken. My lord, inherent lack of jurisdiction, I possibly cannot make such a loud voice. But lack of jurisdiction is there because it is the secured debt on which. Why? Because, my lord,
this again has been commented upon by the Honorable Supreme Court, saying that when you have the alternative forum available, then the case made out has to be total lack of jurisdiction.
Possibly, my lord, kindly consider, may I, a judgment which my lord has seen and my lord has cited it when my lord was this side of the bar, and my lord is aware of it, yet my lord will kindly give me liberty to say, ordinarily. My lord, the catchword of the Supreme Court is ordinarily. Why? Because, my lord, the court has to consider. My lord, the court kindly consider, my lord, if I have to go to the rigors of another DRT with trials, my lord is aware how long it takes.
Why should it?
Observation.
My lord, if
the stay won't take long, the prima facie case which you have, you say that you have, if you project it before the DRT and the DRT is satisfied, why won't you get a stay?
My lord, may I indicate one by one? If my lord considers 2010 volume 8 not a new judgment, my lord is aware of this. Satyavati Tandon. My lord, the important factor which the Supreme Court considered in this judgment was that writ petition should not be entertained, but the word is ordinarily. I am on the point, if my lord considers And this is something, my lord, which I am not showing, my lord, for the first time. My lord is aware of it. Para, my lord, 42 onwards. And precisely 46. Hello, kindly not at least this. If I am entirely on surface, my lord, I will not come to the High Court. I will go to the I am not on. And for a moment, my lord, though the present cause of Rule 86 notice contemplating auction has emerged, and I have included it in part of my writ petition, my lord will kindly ignore that aspect. May I withdraw all those prayers made qua the surface action? Then my lord will test the bank's conduct. My lord, a person, my lord,
then if you are not challenging the sale notice itself, then in that case, I can invite affidavits and decide that. But I will not stay the sale.
But my lord may say not to take any coercive action. That my lord may say in light of the
But then that again will be an indirect stay on the surface action, which is why I said the entirety of it can be addressed more effectively by the
if my lord takes that 86, I'm only making it comfortable so that my lord, we are not eyeing a surface action. But if my lord, this is allowed,
it is in fact that only. The writ petition is aimed at that only. Ms. Sena, what is your explanation to the compound interest claim part?
This I'll have to take instruction, Your Lordship, because as of now, it's a one-line annexure which was indicated.
Let the litigation end.
No,
my
no.
lord, I've been protracted into.
I will come back with specific instruction on this, only on the compound interest, but whatever has fallen from Your Lordship and whatever I have indicated from page 111, the matter is crystal clear, Your Lordship. There is an alternative remedy available here. E-auction.
Where is the earlier letter by which you were granted extension?
My lord, I have shown. My lord may kindly consider page 119. Absolute deviation for this content. My lord, this is a contract. Even if I consider it's a composite OTS, today, my lord, the entire money is paid. Be it writ petition number 1 or be it writ petition number 3. And the chart which my lord is finding at the bottom is the manner in which I have paid, and they have adjusted according to their fancies. My lord, kindly see, there is no mentioning of any further amount payable, interest payable, or time being in essence. My lord, squarely on this point, my lord, same position now. My lord, Her Lordship, my lord, Honorable Justice Shampar Sarkar was in session of a similar circumstances.
कहीं से रिफ्लेक्ट नहीं हो रहा।
Thereafter, my lord considers the one line, my learned friend is absolutely correct. One line, but I will never come out of this vicious circle. One line after accepting the entire amount, they won't know. No reason. I leave it upon my. Similar circumstances, the Honorable High Court in another coordinate bench, only for persuasive valid, may consider exactly bang on the same circumstances. The court said that once you have accepted the money without raising any objection, you cannot reside. 2 says that when you have accounted for interest, in that case, my lord, you have accounted for future payments to be made. You just cannot reside.
Kindly see.
And my lord operates estoppel on them. 4 exceptions, if we talk about, my lord, at least, if not jurisdiction, but natural justice, definitely. And my lord, palpable injustice in their action. But I am stuck up in this vicious circle. After having paid, my lord, how can the bank come up with an auction of my property? And moreover, against a dead person, I am not troubling, my lord. With that, I will take that cost to the DRT if required. But that will not be required, my lord. The entire money they having received, now one line mail says that give me 1.18 crore more. That is my respectful submission. Yes, 2024 SCC online.
This is the relevant paragraph. Just hand it over for a moment.
Well, exactly the same situation. Though there, my lord, the matter started from DRT, DRAT, and then, my lord, it came in civil.
First thing that came to
that is not significant. I'm on the ratio of the point that in the facts and circumstances the court held. My lord, why multiplicity of proceeding? My learned friend has only one submission. Rather, alternate remedy, and 2, I cannot justify 1.18 crore. My lord, that is sufficient for the writ court to exercise jurisdiction. There are only 2 submissions of the bank. I cannot justify 1.18 crore. I need instructions. And to go to DRT. But my lord, I am showing so many exhibits that I have acted upon.
But Mr. Mishra, you have almost accepted the subsequent proposal also. Please come to page 151. The mail at page 152 is of 22nd of May, 2026. Isn't it?
27th of May, my lord, is indicating the first mail on the top.
Page 152. This is May 22.
Yes.
This is May 22, 2026.
Yes, my lord.
Now, after this, kindly come to page 151. Page 151, somewhere in the middle. On Wednesday, May 27, 2026, at 11 a.m., you write, pursuant to our meeting, please find attached the email for our willingness to submit 1 crore as our proposal. So this again becomes a sort of a contract between you and the bank.
My lord, may I only indicate? First of all, my lord, I have annexed it. I have to respond to this. My lord, if I make a proposal, my proposal doesn't become a contract.
May not become a contract, but then
there is no contractual acceptance.
Maybe, but there is no disagreement to that also, that this is due. Instead of 1.81 crore, you want to pay 1 crore. Now, whether they will accept at 1.81 crore or not, you would have come immediately then that no, this 1.81 crore is absolutely arbitrary.
So the arbitrariness is at page 153 thereafter.
153 is right, because you accepted the you want the amount from 1.82 to come to 1 crore, which they do not agree to. Now this again gets into a different kind of a contractual relationship between you and the bank. Now you have to sort it out. Go before the DRT. Again, I say, Mr. Mishra,
on this, my lord, I must admit, my lord, on this, my lord, may I come tomorrow? On this, rest of it, I have not sought for. Let my learned
Mishra, once again, I'll say that instead of inviting observations, because I will have to make observations on merit, enter into it.
My lord.
Whether one view I take or the other view I take. If I go into merits, I will go into merits. If I don't go into merits, I don't go into merits at all and relegate you lock, stock, barrel to DRT, where you can fight with peace, with a rider that DRT will dispose this off before the 2nd of September.
Otherwise, I would have accepted my lord's suggestion, my lord, very respectfully, I would have gone to DRT.
Because
But under these circumstances, my lord, I'm absolutely, my lord, my understanding, it's a fit case. On this, my lord, my lord, on this, I come tomorrow. I come, kindly give me
you
10
write
minutes
to them,
tomorrow.
then you say, I am ready to keep it under no lien account, subject to acceptance of the proposal. Then provide your approval and guidance. You want it to be toned down. They may not have agreed. They have proceeded with sale. And now you want the SURFACE to be stopped. Mr. Mishra,
I
please.
may
go
come
to
tomorrow on
the
this. I cannot read
Tomorrow
it
is a
here and now.
holiday. Tomorrow is a holiday.
Yeah.
Let us have it today.
Well,
It's
day after
better.
tomorrow. Well, kindly consider, I cannot read this and come with a submission.
It's
Kindly
clear,
give me
Mr.
day after tomorrow. I understand the auction is on 2nd of May. I'm still within the range.
2nd of September.
2nd of
2nd of September. I'm sorry. Kindly keep it day after tomorrow. On this, my lord, I have to read between the lines to make submission. I cannot casually make any
Mr. Mishra, go before the DRT. I am telling you, it will be
My lord,
better.
that's a normal thing which, my lord, I know my lord will send us to DRT.
Yes,
That is
why-
the usual. But my lord, there are exceptional cases. My lord, this squarely falls, my lord.
This is not
If
one.
my lord considers it, that a person who is intending to pay and has paid,
Very
now
well.
whether 1 crore or not, I say that, my lord, I will delve into
Why
further.
not? Why not before the DRT? You can make this submission before the DRT also and get an order. Why do you want the High Court to enter into it when the Supreme Court has time and again been saying, please don't?
Well, that I am aware of. But I am aware of that Supreme Court and
My hands are absolutely tied.
but my lord has the jurisdiction of SURFACE matters. My lord, essentially to ensure.
Of SURFACE matters only when SURFACE is wrongly invoked without jurisdiction. I have that jurisdiction. I have the jurisdiction to say that you have acted without jurisdiction. I don't have the jurisdiction when they have jurisdiction. That is the difference.
May I only beseech my lord to kindly give me some breathing space for day after tomorrow. Only 10 minutes. Let my learned friend also come with 1 crore 18 lakhs. 10 minutes, if my lord grants me, I will either go to DRT or my lord will grant me remedy. Either of these two options, the facts have been deliberated. It will not consume time. Day after tomorrow.
Come back day after tomorrow. Ms. Sinha, you also.
Yes, I will come out with this.
Please,
The compound interest, yes.
clear with all the instructions. Better, Mr. Mishra, you agree to go to DRT instead of this court making observations on merits. Because it
Well,
will
merits, my lord will make observation in my favor. Why? Because my lord, my documents
I
support
will
my
not
cause.
like to go into these questions because there is nothing crystal clear. You say, somebody says one.
One and a half years.
After the 1.8 crore email, you are coming in August.
Yes,
The 1.8 crore email is of May. You had deliberations in between.
Yes, they said
Therefore,
this will not be acted upon.
Therefore, this immediate precursor of the writ petition is nothing else but the 8-6 notice, which squarely falls within the domain of DRT, Mr. Mishra. We are unnecessarily postponing it to Thursday. We can do it today. Tuesday is a good day. Thursday you can have. Thursday you can begin from DRT.
I will not be able to have the matter put up before the DRT.
I will direct that immediately. Tomorrow I think DRT will be open. We have a holiday. DRT
No,
has,
my lord, it is central government holiday. DRT will also.
DRT will close. Day after tomorrow, I'll say that you will take it up immediately on the day filed. I'll make that direction.
Can I take instructions, my lord, for my lord, 5 minutes, my lord?
12 noon.
Grateful, your lordship.
Next. Good morning.
11. Yes. 11, my lord, I am for the petition.
Yes.
So the subject matter is, my lord, the SURFACE notice was, my lord, handed over to me, my lord, 13-2 and 13-4 for an amount, my lord, of below 20 lakhs. That was the sum and substance, my lord. My lord, I have, my lord, order of my lord, district magistrate has already been passed. I was, my lord, এর অর্ডার ছিল ওইটা কোথায়? এর তার জাজমেন্ট আছে কোনো আর্টিকেল? There was, my lord, an order I was relying on, my lord, by this coordinate bench, my lord, which Justice Bistro, my lord, when his lordship was taking up these matters, my lord, passed, my lord, the judgment, my lord, that particular, my lord, surface by NBFC, my lord, surface notice can be only have a, my lord, if the amount is, my lord, more than 20 lakhs. Below 20 lakhs, my lord, it cannot be. My lord, based on the 13 to and 13 notice, my lord, already, my lord, they approached the.
But Kotak Mahindra Bank is a scheduled bank. It's not an NBFC.
No, my lord, what has happened, my lord, kindly sees.
Kotak Mahindra Bank is an NBFC. I don't think so.
No, I'll just, my lord, indicate what happened, my lord. Finally takes up
And what will happen to Federal Bank and Shobha?
no, my lord, there was. My lord, kindly considers, my lord, that Bajaj Finance Limited, my lord, initially, my lord, granted me the loan. After, my lord, Bajaj Finance Limited, my lord, the notices were of 13 to and 34 was also, my lord, with by Bajaj Finance. After that, my lord, Kotak Mahindra, my lord, came into the picture. Therefore, my lord, initially started off as an
Banerjee, what will happen to Federal Bank and Shobha? Because those were not placed
my lord,
before the honorable
may I, my
single-
lord, may I, my lord, only, my lord, pray, my lord, to give them a notice and come back, my lord, any other day, my lord.
Oh, come back.
This is, my lord, suddenly, my lord, coming to the list, my lord, without, my lord, any of us mentioning.
None appears for the bank. Full stop.
I'm accepting it. I've made an offer of 1 crore. I read it, my lord, right now. But I am not proposing 1 crore, my lord. Kindly consider my anxiety and the level of harassment I have.
If they pay that, and it can be any.
Yes, yes.
Grateful to that.
Grateful, your lordship.
My lord, I am appearing on behalf of the petitioner, my lord. Petitioner made an application for new connection for his submersible pump on 20th November 2024. Immediately thereafter, the respondent concerned issued a quotation
Lordship,
21st.
Lordship, earlier this matter was heard out also. My lord, the problem is that we received a objection from one Boytunath Shuren. Now, Lordship, the problem is that
Yes, madam. I served notice.
it was served by them.
As I did not.
Subsequently, my lord, Justice had instructed me to serve them also. We have also served them, but no.
They did not.
No such person found in that address, Lordship. That is the report, Lordship. My lord may grant us police assistance, Lordship. We shall effect the connection, Lordship. No issue.
Otherwise, he is entitled.
Lordship.
The petitioner complains of inaction on the part of the respondent, WBSCDCL authorities,
হ্যাঁ, নাম দিয়ে দিচ্ছি।
Hotel Miller, I am for the petition. Lord, your lordship, your last occasion heard this matter as.
Yes,
Have taken instruction, madam. There are two properties which is lying mortgage with the private respondent, madam. The dispute is with regard to 2 decimal what the petitioner has raised, madam. Now, the private respondent has got a registered mortgage in respect of that 2 decimal also, which is forming part of RS Dag number 122 and Khatyan number 693. Now, petitioner's claim is RS Dag number 122 and Khatyan number would appear from my lord. The petition at page number
16.
16, madam, which is 240, Khatyan number. My Khatyan number is 693. So our contention is that we have taken possession of that particular property which is lying mortgage with private respondent, and before taking possession, the property was also made to be identified by the registered LBS. He identified the property
My lord,
and thereafter it was taken
the
possession.
notice and board which has been affixed, my lord, that is below demarcated portion where we are residing, my lord. That is 30 decimal lands in respect of 122 Dag number, my lord. They have affixed the board over Dag number where we are, my lord.
It has been affixed in his property. is what
Yes,
he's saying.
let them remove the same, my lord. We don't have any, my lord, objection.
So
Yes, I have also photograph annexed with this.
structure and there is.
Yes, this is our portion.
Which
Is that the board is in his demarcated
Yes,
portion.
yes, this is our portion. That is the problem. We are unable to sell. Nothing, my lord. We are not the borrower. Only 2 decimal has been mortgaged out of, my lord, 1.37 acres, my lord. We are in possession of 30 decimals since
I
long
think,
time.
If the board is in his property, please remove it. Otherwise, he'll be in difficulty.
If we could
Only this prayer, my lord, I made in this petition.
to identify, madam, my contention is that
Yes,
small.
let your LBS be sent along with our LBS. It will be identified as regards to
Who
2
is
decimal.
appearing for the state?
State Nilanjan Bhattacharya.
State, nobody is appearing.
No, yes, my lord. Last occasion appeared.
The BLLRO can solve the problem.
Yes, madam.
He can get it done. Serve a copy on the government pleader's office. None appears for the state. Likun.
I am for WBC.
এই আছেন তো?
কি ভট্টাচার্য আছেন?
You have brought?
Yes, my lord, I have brought, my lord. I have handed over a copy to him yesterday also.
Yes, Mr. Bhattacharya, you have your client has received.
This is the copy of
RGRO, kindly see your lordship's order dated 12th of August, my lord. Para 3 and 4, my lord. As per order of the learned RGRO, they have revised the motor capacity, my lord, from 39 to 28 kVA. And now
Yes.
it appears from your order, my lordship, kindly see para 4. It has now toned down to 24 kVA. I have no problem in this. But my lord, problem is they are sending the earlier bill without revising the sale to me, and that is the my grievance, my lord.
Mr. Bandyopadhyay, he says you have toned down the contract demand, but the bills are again on the basis of the earlier contract demand. That is
No,
what.
my lord, we raised, my lord, the outstanding bills he has already paid in December 2025. Thereafter, we have, my lord, raised quotation, and my lord, that quotation is due to be paid within 31st August. That quotation we have already sent in respect of, my lord, the reduced load.
Mr. Bhattacharya, please take instructions. Mr. Bandyopadhyay says that he has raised the quotation as per the revised load.
Yes,
It is
My
not
lord,
as per the old load.
my lord, my humble submission before your lordship. Kindly dispose the matter, directly send another copy of the bill, and I am ready to pay their bill, my lord.
He has said, he
Without-
says he has already sent it. 31st August is the last date. That is what he's saying.
I also handed over him.
My lord, my lord, yes, my lord, my lord, kindly direct them to send another copy, my lord, for my perusal, my lord, so that I can make payment, my lord.
He
And
has
my lord,
already
only
sent. How
direct,
many copies will he send?
it has been misplaced somehow, my lord. That is why I am
Can
praying.
you send one to Mr. Bhattacharya?
I have handed over him.
He wants another copy. He may have misplaced it.
How can I have given him the one this
Yes,
soft
my lord,
copy.
yesterday,
It shows.
my learned friend has handed me.
Yes, it shows 83,616.
Previously, it was 1,58,091.
It is
That
lower
is
than
the-
what was.
That has been perhaps that has not been calculated as per present 24 kVA, my lord. If that, kindly they direct them to revise the bill again, and I am
No,
ready
no,
to.
no, Mr. Bhattacharya, I think you are not right. If you have the bill in your hand, I can show it to you. You have the bill in your hand. Please take it. Please take
My
the
lord,
quotation in your hand.
my lord, that I have not received, my lord, due to
No,
some.
no, you have. You said he has served it on you yesterday.
Yesterday, my learned friend have on me the postal receipt and the track report, my lord. From
You
that
have
it
not
appears
sent.
that my client
And your location I have handed over.
No, no, you hand it up. He is not well.
postal
Actually,
receipt.
I have sent him the one soft copy also.
This.
Yes.
Mr. Bhattacharya, you
No,
may
my
be
lord.
having it on your mobile.
Yes.
He has sent a soft copy to you.
In that case, my lord, I am my lord, kindly dispose the matter with the direction to send another copy, my lord, for my perusal, my lord.
How can I
Well, that
direct them
will
unnecessarily to send copies? They have already sent to you, to the client. You will be free to take it from Mr. Bondopadhyay. He will send a soft copy again to you. He will be sending the same thing. I don't find that the contract demand has not been lessened. It has been lessened. I can see it. It is now 21084 watt.
Yes.
So it
my
is
lord,
not
the problem is
31.
My lord, due to my personal difficulty as well as illness, my lord, I am not in a position to go regularly, my lord, to the court. That is
That
why.
I understand, but for that you send one more soft copy to him. That will suffice. You don't have any clerk here in the High Court area. I will then
No,
direct him to.
no, my lord, I have no clerk junior at all.
You send one more copy to his
WhatsApp.
to the client.
To what? Oh, to the client.
Yes, yes. By post you
Yes,
serve
yes,
one
my
more.
lord. Yes, my lord, I am grateful, my lord.
I will again sub the quotation.
Yes,
Quotation.
same quotation.
And that will solve the problem, my lord. I am grateful, my lord, before your lordship.
Don't disconnect.
No, that will be reflected in the bill. Thereafter, my disconnection.
But Mr. Bhattacharya, if they send it now, your last date will be crossed. By 31st is the payment date. You have it in on your WhatsApp. Why don't you share it to your client through WhatsApp so that he can pay?
My lord, today is 25th. My lord, if they send today,
It won't be possible. I will pass the order. He will communicate. They will send it probably on 30th. He will get it on 5th of September.
my lord,
By
if
that
that
time,
is
everything
so,
will be gone.
if that be so, then I will have to pay, my lord.
May I suggest one thing, my lord? Kindly ask his client, my lord, to take it from the officer.
Yes, I will do this.
Yes, yes,
Direct
yes,
the
my lord.
to approach the station manager and collect a copy and pay if he has not received.
Yes, my lord. And dispose the matter, my lord.
Yes.
I am ready to collect, my lord.
আচ্ছা, which according to না, which prima facie করে দিন, which prima facie, তার আগে ওটা কেটে দিন, since থেকে কেটে দিন, লিখুন। A copy of the quotation has also been produced in court, which shows contract demand to be 21084.25 watt. Full stop. Prima facie, the same appears to be in terms of the order passed by the grievance redressal officer. Full stop. What is how much will it come if it is converted into KVA?
It comes to my lord 24.80 kVA.
Yes.
And one of the last date is my lord 3rd September 2026.
3rd September. So he has time. Full stop. However, comma, since the since now, if the petitioner, comma, has not received the said quotation, the petitioner will be at liberty to approach the relevant station manager and collect a copy of the quotation from the relevant station manager. Since it has been submitted by Mr. Bondopadhyay that the last date for payment of such quotation is September 3, 2026. 3/2026. Full stop. In view of the aforesaid comma, no further order needs to be passed on this writ petition. Full stop. WPA 14714 of 2026 stands disposed of, no cost.
Yes, my lord. I am grateful, my lord.
You will record a recommend. Postal track report and quotation, copy of quotation are taken on record. Next.
My lord, 16, my lord, I am praying for an accommodation on behalf of Mr. Dilip Kumar Samanta. My lord, he is hospitalized. He is supposed to be operated yesterday, but my lord, due to some medical emergency, my lord, operation postponed, my lord, at least for 4 weeks, my lord.
This writ petition is not maintainable in any case. It is not maintainable.
My lord, I have to take instruction. My lord, kindly adjust.
Instructions unnecessary.
My lord, I have to because my lord, the advocate on record is not. He is looking after him. My lord, at least for 1 week, my lord.
I will say that this will not prevent the bank because this has been continuing for some time. I'm not dismissing it since.
Also require a disposal. I mean, if not today, on an earliest possible date, my lord, because once a writ petition is pending, my lord, we'll have to disclose it even if we go before the section 14.
Yes, this
That
is not proper. Ask the client to take make alternative
My
arrangement.
lord,
because
day
it
after
cannot go
tomorrow,
on
my
like
lord,
this.
I have to take instruction. Day after tomorrow.
Very well, I am making it day after tomorrow.
Day
Take instructions. Day after tomorrow করে দিন। এটা new motion এ দিয়ে দেবেন because this has been pending since long. I cannot keep it. Unnecessary, not maintainable writ petition should not be kept. Day after tomorrow. Yeah. Take instructions. Either you appear or I dismiss.
17, my lord, I am appearing on behalf of the petitioner.
So last occasion, my lord, director would file a report. But
Last occasion, my lord, your lordship heard the matter and after hearing, your lordship was pleased to call for the record. But facts of the case is that, my lord, the respondent number 5, the father-in-law of the petitioner,
My lord, joint inspection has been done. May file a.
was the owner of the land in question. The husband of the petitioner, being the elder son of the respondent number 5, constructed one dwelling house in the year of 1997, and in the year of 2012, my lord, she made an application for new electric connection to his premises, and on the basis of the said application, she distribution company limited, my lord, give him the electric connection. But in the month of September 2025, my lord, the meter room broken down and consequently the connection was disconnected. Immediately thereafter, the petitioner made an application for restoration and shifting the said line. On the basis of that, my lord, the distribution company limited issued a quotation of rupees 1,000. Accordingly, the petitioner paid the amount, and thereafter, my
I
lord,
have not been able to find out any alternative route.
My lord, the route earlier through which the line was given to her is the best route. Alternate route is not economically
There is no
feasible
alternative.
because there is very big pond.
What is your objection if he gets
the
elected?
objection
My
in
lord,
this
may kindly
matter,
see the
the petitioner is
sketch
not
plan.
the owner, number 1. Number 2, the private issue or private will, including father-in-law of the petitioner,
owns the sole owner
of the land.
of the land. But
which
his
electricity
intention of the petitioner to draw the electricity over the property of the private respondent.
Very well, then I am referring it to the district magistrate.
My
He
lord,
will
there
find
is a
out.
common
My lord,
passage.
my lord, kindly consider, my lord, if the connection given in its earlier position, I have no objection, my lord.
That is
My lord,
the-
my requirement is connection. My lord, since 2012, my lord, the
connection may be
petitioner.
given from the earlier position. There is a common passage. We are ready. That is the best possible route.
I have no objection, my lord. My requirement is connection.
But all property belong to the my lord, the
His
sole
father-in-law
private
and
respondent.
petitioner is
But
daughter-in-law.
let the matter be referred upon the.
No, my lord, my lord,
She is your daughter-in-law. What is your problem?
my lord, since 2012, my lord, the petitioner enjoying the electricity.
The all private respondent facing trouble for the activities on the part of the petitioner.
So what? So that is sort out in a
my
civil
lord,
suit.
my lord, can refer the
Petitioner is a lawful occupier.
I will grant electricity supply to her.
Yes.
And thereafter refer it to the DM.
Yes, my lord.
Sort
My lord,
out in
my
the-
lord, since September, my lord, the petitioner is without electricity.
My lord,
I
she has
shall
been
file the
enjoying
objection to the
electricity
report of the
since
my lord.
2012. Since
Since 2012, my lord, petitioner is enjoying the electricity, and my lord, last
father of
1
the-
year, my lord, the petitioner is
father of
without
the- my lord,
electricity, my
father
lord.
of the-
Yes.
I've heard you.
My lord, father-in-law of the petitioner is the sole owner of the property when the meter was existing. And my
Is
lord,
there
number
any
two,
pole going to be erected?
My lord, one pole may be required, one or two. That is on the common passage.
Pole is on the common passage.
My lord may see a sketch plan. My lord, she has been enjoying electricity since 25/11/2012. It is old connection. It was disturbed due to storm. Line was dismantled, and we are ready to give it again through the common
The
passage.
petitioner complains of
That because the final decision by the district magistrate, I have the approach.
Definitely, he will act.
But
That is rule 3, works of licenses rule says so.
Kindly that may be recorded. Petitioners
Advocate
cannot
record.
claim equity in future.
Yes, this ওটা record করে নিন একটা, it is recorded that through which it was there till September 2025. You have not prayed, you did not pray for shifting prior to September 2025 upon it being disconnected through natural calamity. Now you are obstructing.
Yes, DM is not party. Let him made party.
Not required. You will approach the DM. I have passed an order, sir.
My lord.
Grateful, your lordship.
My lord.
Time for the petition.
We are on the second round of
Lordship directed for second
As
inspection, Lordship.
Lordship, my lord. Things have come up with a different scenario. My lord, the land which was previously submerged and inaccessible has been repaired, my lord, and it was found that the adjacent houses were being supplied connection through that particular route. And my lord, now, my lord, subject to compliance, my lord, we have got no issues for providing connection. This is the new report.
Problem solved. Good. लिखे
Lord, I have something to say with regard to the report. I have not been handed over the copy of the report. I cannot.
Hand over the copy of the report. He is getting electricity supply through the portion. What is the problem?
I have received. I have received.
He wants also. Give him a copy. Let him read.
Lord, whether my right is being affected or not, I cannot.
What is your right?
Joint inspection has been conducted in presence of all the parties.
The report must be handed over to the private respondent. I should give a copy.
At a Chaudhary.
Well, kindly fix day after tomorrow. Directly to hand over the copy of the report.
What will you say, Mr. Ghosh? What will you say? He is.
Please go through it. It's very
On previous day,
No,
subject from the subject petitioner, aerial connection.
But I have given Mirror. Let him go through it. It's a very short report of a single page. Paragraph 6, Mirror is the relevant part.
On previous day, it was submitted overhead.
No, it's not possible because it's the passage is of only.
They are laying underground cable. Underground cable through the passage through which all others are getting.
Adjacent houses are being provided through that.
Paragraph 6 says so. Underground cable.
And the poles which were seen belongs to the municipality.
Report
For
filed
district
on
light.
behalf of CSC Limited is taken on record. This matter. শুধু লিখবেন report filed by CSC Limited is taken on record. আচ্ছা, copy served on all. Next.
I beg to appear on behalf of the petitioner. It is that matter where the person consumed electricity was acquitted from charges, theft charges. And thereafter he applied for refund of the final assessment.
We have seen the judgments of the Honorable Supreme Court also now.
And my lord, I am relying upon a judgment of this honorable coordinating bench, my lord.
We have shown you Supreme Court judgments, sir.
That those judgments were considered by this honorable.
How can this judgment be considered by this bench?
Reporting to this. ছবি তুলে নেবেন এটি কনসিডার করেছেন
But this judgment has already been stayed by the division bench and already.
No, where was this judgment considered?
No, this Supreme Court judgment has not been
Castron Technologies, where was this considered?
This judgment, I believe, Lord, that judgment was also considered.
Where? Show me that. Please show me.
Supreme Court judgment considered foreign.
Yes, sir. It's not considered. The judgment which you now handed up to me, there is a problem there because final order of assessment was not passed in that case. Please read paragraph 28.
In my case, Lord, final assessment was passed
That is
and
why
we deposited.
That is the distinguishing feature. Here, since final assessment was not done,
Thereafter, we preferred an appeal.
That is why you have preferred appeal. Here, since final assessment was not done, they had to return everything, whatever was taken.
It is the duty of this special.
May I submit one thing subject to lordship kind approval? I know.
Let him conclude.
But special court has to decide also the civil liability of.
Special court will decide only if it finds that there is theft. If it doesn't find, that is why the Honorable Supreme Court, please see this, the Supreme Court judgment which was handed up to you on the last occasion.
I find that was not decided.
It was decided. Kindly see second page, last paragraph.
It is stated, my lord, as regards subsection 5 of section 154 of the 2 2003 Act, the special court gets jurisdiction to determine civil liability. Civil liability of both. The
please read thereafter.
civil liability in the event it is found that the consumer or person concerned has committed theft of energy. In this case, the finding of the court was that charge of theft has not been established. In this case also, my lord.
Yes,
Therefore, there is no occasion for special court to make adjudication under subsection 5 of section 154 of the said act.
So, therefore, in this case also there was no occasion. So, therefore, this stands.
But
if
special-
the special court also comes to a conclusion that there has been theft, and it determines the amount payable, then in that case that will override the assessing officer's assessment.
Special
But
court could have decided.
has not decided. Could have decided is a different thing. Has not decided because there was no theft. It could have decided only if there was theft. If there is no theft, what will it decide? It will get jurisdiction to decide only if there is theft. If there is no theft, it falls within the domain of the civil liability.
My lord, kindly consider this and decide the matter according to you.
One point I subject to Lordship kind of. My first point that what my learned friend is submitting, this matter has been stayed by the appeal court. And secondly, what they have stated that Topenshen judgment where it has been referred, that where the provisional assessment has been made, final assessment has not been made. Though, albeit this is not pertaining to this matter, but in spite of that, may I submit one thing that against this, a division bench has already set aside that order. Where is
that?
Already set aside. And it has been specified that there is no bearing because it is based on two different footing and it is based on preponderance of probability and another is based on beyond all shade of doubt. Yeah. But this judgment has already been set aside by this division bench. And in this case, in 2004, final order of assessment has been passed. Sat tight over this matter. And this acquittal order has been passed in 2014. And after 12 years, they have filed this writ petition.
I have assigned
Nobody can sleep over his own right.
Reasons for delay I have assigned.
You have?
Reasons for delay I have assigned
For
categorically
12 years.
12 years.
And this Saraswati Gorai case, where your Lordship was also standing on the same footing, was pleased to dismiss the writ petition. That has already been placed before your Lordship, and that has also been handed. The copy has been handed to my learned.
Very well.
I beg to draw.
After tomorrow,
I beg to draw my lord's attention.
There is less time.
My lord, I beg to draw my lord's attention with regard to the provisions of section 154, subsection 6.
Yes.
My lord, kindly consider it.
Already.
Your lordship consider it and decide it. I have no. I beg to draw your attention.
Please.
In case of civil liability.
Just 1 minute. Let me read. Section 154.
Subsection 6. In case of civil liability, so determined finally by the special court is less than the amount deposited by the consumer or the person, the excess amount so deposited by the consumer or the person to the board or licensee or the concerned person, as the case may be, shall be refunded by the board or licensee or the concerned person, as the case may be, within a fortnight from the date of communication of the order of special court, together with interest at the prevailing Reserve Bank India prime leading rate for the period from the date of such deposit till the date of payment. Explanation: for the purpose of this section, civil liability means loss or damage incurred by board or licensee or the concerned person, as the case may be.
Due to that is important.
Due to commission of an offence.
Now, Mr.
referred to in section 1.
Mr. Mondal, let us stop here. Due to commission of an offence, in a case where there has been unauthorized use of electricity, but it has stopped short of becoming an offence, how will the special court gain jurisdiction there? There is an unauthorized use of electricity, but it is a little short of becoming theft, but it is still unauthorized. So in that case, this will not have jurisdiction. This is what the Honorable Supreme Court has said. Honorable Supreme Court has said that it will have jurisdiction to decide only if it decides that there is theft. If there is no theft, acquitted, it cannot retain jurisdiction. It becomes pure civil liability to be assessed by the assessing officer. If it reaches a conclusion that there is theft and then it decides, then in that case, it will override the assessing officer's order.
Mondol is also aware about it, but he is trying
No,
his
I-
luck.
I leave it to your lordship decide.
Heard Mr. Mondol, learned advocate, appearing for ওটা বরঞ্চ ইয়ে করে দিন ওই পর্যায় ফর অর্ডারস এর বা এরকম একটা হেডিং দিয়ে কিছু করে দেবেন, নিউ মোশনই থাক, উপরে থাক, করে দেবো শুধু। নেক্সট, ও নিউ মোশনই থাক। Yes.
My lord, I am for the petitioner. My lord, earlier occasion, that is the jurisdictional issue. That's
Your lordships direct me to take instructions, what has happened. Well, my client, Landerson's client is very intelligent. Well, there is a road, this side South 24 Parganas, this side North 24 Parganas. His house is situated in the border. Now he is committing theft from the service line of Minaka supply. That's why the Minaka station manager lodged FIR to the Jivantola police station and assessed the final assessment.
my lord, my lord, kindly, my lord, my lord, can you annex P1 page 11, that I have
Yes, he has
applied for
explained
electricity and I am enjoying
You have your
electricity under
you have
the,
your electrical appliances in South 24 Parganas.
and also, my lord,
You are drawing from not.
no, I am paying the bill electricity and also that.
अरे भाई तुम्ही सबটাই জানো আর চেঁচিয়ে লাভ নেই অ্যাফিলিয়েট হতো
This writ petition
One, my lord, there was an inspection which was supposed to be carried out by the.
This is connected with item
Item number
38.
31 and
Why
38 are-
Madam will recall to connect it.
I am praying an adjournment of 1 day.
I am appearing for, my lord, I am appearing for respondent number 789.
I am appearing for 6, my lord. 6. Respondent number 6. Private.
If
respondent
there is
number
a prayer for adjournment, I'll be taking it day after tomorrow.
Much obliged. Also, one leave may be granted for one additional party because this land is not possession for the writ petitioner.
Day after tomorrow, and please be here instead of being in the car, be in the court and argue.
Serve a copy of the report on us prior hand, my lord. We can then come prepared if they serve it.
He doesn't have it seemingly. Next.
Grateful.
Not today.
My lord, item 38 is
21 and 38
Both of them
both
will
are
not
direct.
today করে দিন।
Public.
21 হয়ে গেছে।
My lord, I am for the petitioner. My lord, these are the affidavit of service, my lord. I should be candid with you, lordship, my lord. All respondents are served, 7 except respondent number 14, my lord. I have tried twice, my lord. Although my allegation against the, my lord, licensing company, my lord.
Why have they been arrayed as parties then, the others?
My lord, he was carrying out the work, my lord. My lord, the
transmission?
Yes, my lord. They are the electricity company, my lord. Installed, my lord, the electric pole on my land, my lord. The petitioners
compensation or removal?
My lord, for removal, my lord.
Approach the DM, that is the authority.
My lord, in that event, my lord, I have not made any representation before the
I'll grant you leave.
Yes, my lord.
The authority.
According to us,
Yes,
it is on the roadside.
Yes, that
And
DM
that will be decided by, because our specific case, my lord, that is on my land.
That's the jurisdiction.
Distribution line though, not
Yes.
transmission.
Yes, distributional line.
The transmission line.
The petitioner complains of arbitrary action
my lord. That means, my lord, they are after, my lord, giving this objection, my lord. My lord, they have erected, my lord, that pole, my lord.
They have apprehended that it is their land. My specific
My
instruction,
specific
it is-
case, my lord, it is
it
on
is
my
the
land.
upon the vested
but
land.
I don't think it is prior to the
Yes.
erection. Karon, if you see this, জমির প্রাচীর দিয়া ঘেরা আছে এবং দরজা করা আছে বিগত 4-5 বছর আগে এই জমির উপর বিদ্যুতের পোল বসে
Initially, there was one, my lord. We raised the objection,
and done prior to you raising the objection.
My lord, this is second one, my lord.
But then you want removal of all of them.
Yes, my lord, both of them.
His house was totally safe by boundary wall.
My lord, that is their
Amidst
contention,
that,
my lord.
The WBSCDCL authorities have erected PCC poles over the petitioner's land with the help and aid of the private respondents. Full stop. Mr. Kole, learned advocate, appearing.
Your lordship is so fluent in Bengali as well.
Yes, I have read Bengali.
20 Lordship kindly takes up on the.
Lord, this is the third instance, my lord.
No.
Third instance.
First time or second time? Lordship, I'm praying for not today only,
This
Lordship.
petitioner
Not today.
is incorrigible, my lord. Habitual offender. Four times his connections were been disconnected.
Lordship, on
Four
Thursday.
times he has been found tampering from the main
Not today.
service line.
কি হলো কোথায় গেল কোথায়
4 বার।
24 my lord.
প্রমাণ তো করতে পারে।
24.
ওটা তো একটাতে। ওটা তো একটাতে।
একটা বাকি এটা তো দুটো।
24 একবার কল করুন কি আছে দুই পক্ষে that matter
Of the state my lord.
have you taken instruction sale has gone through
Sale has not been completed.
My lord, I want to invite an observation of this court on this.
I'll just ওইটা রেকর্ড করে নিন
I am for the status.
Then in any case, the
under the National Housing Bank Act.
whatever
Now, my
it
lord,
is.
the objects of the National Housing Bank Act are to promote housing between economically weaker sections of society and low-income groups.
Very
My
well,
lord,
you
permits
make
me to
your
convince my lord
submissions.
otherwise.
Make your submissions.
Now?
I don't think prima facie that you will be able to get over the bar of Shobha. Before that, Federal Bank, and then
But my lord,
several
Shobha
others.
has not considered, there is one more after Shobha.
That is not for me to say.
There is
If you can argue
Yes,
from
no,
the
my lord,
larger bench of the, not for me to say. I am bound.
come back after.
safe for today.
Our short matters are there.
You convince Mr. Majumdar? I don't have any problem. Convince him.
Well, he can
Take much time already.
Tomorrow there is no court.
I don't think this will conclude before 3. If it concludes before 3, I will go serially again.
Not much, my lord. 30-40 minutes of your lordship.
40 minutes, please. 1 hour.
My lord knows that I am economical, so by submissions.
Economical few.
So we can safely leave the station right now.
I'm not releasing anything.
No,
That
I am trying to convince Mr. Minor.
You also have not made any arrangement.
ছেড়ে দাও না, আবার পরের দিন করবে।
অপরাধ, তাহলে কি করতে থাকো? Other side কই? ঠিক আছে।
অসুবিধা কিছু না।
হ্যাঁ।
ও এই তো আমি তোকেই মিস করছিলাম, কোথায় গেছিস কে জানে। May I just give your lordship a brief overview of the facts? What happened in this matter? Several suits, several applications, and several other proceedings pending between the plaintiff and the defendant to the suit. My lord, terms of settlement were entered into by and between the parties. The respective parties had signed the terms of settlement. Thereafter, a compromise petition was filed. The compromise petition was decreed by the learned trial court, and the compromise petition was also signed by the respective parties. Now, there, as per the terms of settlement, my lord, all the parties, including the plaintiff and the defendant, acted in terms of the said compromise, as provided for in the terms of settlement. 1 year after, my lord, 1 year after the date on which, my lord, the compromise decree was passed, my lord, the plaintiff comes up with an application that neither the terms of settlement nor the compromise petition was signed by a competent authority, in the sense the gentleman who had signed the terms of settlement on behalf of the plaintiff, my lord, that gentleman had resigned from as a director from the company. Just, my lord, there is one fact to be noted here. Even if assuming, though not admitting, that the gentleman had retired during that period of time, the gentleman also happens to be the authorized signatory of, my lord, the plaintiff, as indicated in the plaintiff itself and the several applications filed before the learned court below. In any event, my lord, during the pendency of the suit or after the compromise decree, the defendant was never informed by the plaintiff that this gentleman is now no longer our authorized signatory, and, my lord, and he has resigned from as a director from the company. Under these circumstances, my lord, an application under section 151 was filed by the plaintiff for recalling the compromise decree on the ground that the defendant had practiced fraud upon the plaintiff and the court. When, my lord, the authorized signatory was not defendant's representative, was plaintiff's representative. The said recalling application under section 151 was decided on day 1 in favor of the plaintiff, and my lord, the decree was recalled. Then, my lord, what happened, my lord, the defendants carried the said compromise, the order recalling the compromise decree to this honorable court by a application under Article 227. Straight away, I take your lordship to that order first. Kindly take, my lord, page 291. There are several, my lord, volumes. This must be in volume 3. Correct?
Additional application on such a volume should be rejected at the threshold.
তাহলে কিছু পাবে না আজকে।
Volume 3.
In code number 2, Justice
Justice Sharma.
In my matter, opposite party Relying on affidavit opposition, such a volume. Don't ask, court has not accepted that. You go and correct it, make a thinner one.
But that was affidavit in opposition, not the petition.
Then compare in this matter the affidavit filed.
No, my lord, kindly now take the order at page 291, disposing of the, my lord, the application under Article 227. This is an application under Article 227 of the Constitution of India at the instance of the defendant number 87 in a suit for declaration of title and injunction, and is directed against an order dated 21st December 2024 passed by so and so, my lord, in the title suit being number 562 of 2023. The connected suit was decreed on compromise on October 18, 2023. The plaintiff opposite party on December 21, 2024 had filed an application. Kindly mark, if it so pleases your lordship, kindly mark the date. The compromise decree was passed on October 18, 2023. The plaintiff opposite party on December 21, 2024 had filed an application under section 151 of CPC for restoration of the suit. Learned trial judge by the order impugned has allowed the said application, thereby restoring the suit to its original file and number. Then, my lord, the submissions are recorded. I am not troubling your lordship about the submissions. Taking your lordship, having heard, kindly take page 292. Having heard the learned counsel for the parties and on perusal of the materials on record, it appears that the application under section 151 of the code was allowed on the date of filing itself without affording an opportunity to the parties to contest it. The learned trial judge, allowing the said application in such manner, has acted with material irregularity. The order impugned is set aside on the said ground alone. This court is informed that November 7, 2025 is the next date fixed for in the suit. The learned trial judge is requested to take up the hearing of the said application on the said date itself, and to make an all endeavor to dispose of it off as expeditiously as possible, preferably within 3 weeks from the date already fixed in the suit. However, opportunity should be given to the parties to file written objection to the said application. Pending disposal of the said application under section 151 of the code, neither party shall take any advantage of the said compromise decree in any manner whatsoever. It is made clear that this court has not gone into the merits of the said application. It is for the learned trial judge to decide the same in accordance with law. But this order was passed, your lordship will find, from the date on 24/9/2025. My lord, since then, at least 20 hearings were held. On some dates, my lord, I am constrained to make this submission. My lord, the respondent and the petitioner before lordship had to countenance, my lord, an unsurmountable, my lord, kind of unsurmountable kind of, my lord, resistance from the learned, the legal team of the plaintiff to get the matter heard. Unsurmountable. And it would astonish your lordship, subject to lordship's kind consideration. The legal team which engineered the compromise decree, the same legal team is now saying that the compromise decree was obtained by practicing fraud. This is one factual aspect of the matter. Well, I will establish the said facts in no time. Now, my lord, now after 2021 hearings, indisputably, what the learned judge says that I am going to register the 151 application as a miss case, which is directly contrary to the direction contained in the order dated 24 September 2025, which says that you dispose of the 151 application itself. So further registration of the case as 151 application as miss case does not, in my humble understanding, does not arise. The learned trial judge says, in complete disregard to the principle of onus probandi, that yes, I will register the case. Now you adduce evidence. So, my lord, no prima facie view was taken by the learned trial judge that, my lord, the plaintiff has been able to establish at least prima facie that fraud has been practiced upon the court and on the plaintiff. Then the learned trial judge relies on certain judgments and passes an order for registering the case. This is the backdrop. Now, my lord, I take your lordship to some of the very important and essential facts now. Kindly take, my lord, page 1025. Well, first, my lord, because my lord, as this, my lord, the petitioner before lordship, this was all about, my lord, forging of a development agreement as we alleged. My lord, I am not here, I am not, my lord, beseeching your lordship to go into the merits, but just the facts.
1025.
Na, impugned order khujche na, 1025 khujche. Volume 8, my lord. My lord, now, my lord, I think your lordship should shift to this mode.
My lord is try to find out the impugned order.
No, 1025. Impugned order no.
Yes. Impugned order will be certified copy.
Last.
Nowadays, I have been told in 3 places the impugned order has to
But
be
it is there also in 3 places here. that Mr. Bas.
That happened, I think, in some 3-4 years back.
Yes.
3-4 years back.
Why?
Before my lord's elevation.
Yes, yes. I have also faced
Yes.
this.
Why?
First annexure also will have to be that.
In the memo of second appeal also.
Well, like my lord, in this intra-court mandamus appeal, now in stay application, we annex the memorandum of appeal. It is otherwise not necessary.
Yes.
Do something. My lord is there. What is this unnecessary wastage of paper?
তুমি ছেড়ে দাও না কাগজগুলো, তাই তো ঝামেলা মিটে যায়।
আমরা যখন তখন তো কেউ আমরা মেমো পেতাম না। আমরা তো স্টে
মানে we were never served with memorandum of appeal, only the stay.
Memorandum of appeal never served. Certified copy of
This was our responsibility.
Original application divorce the, I mean, without the certificate.
They were annexed the certificate. You find
Yes.
out.
Yes.
To put them trouble, other side, you find it out.
Memo was never served until there was a direction.
I don't know what
Stay
it
was served.
requires at all.
Yes.
So, mother, may I take your lordship to some of the dates? List of dates এর কোনো copy আছে এখানে? একটা জজ সাহেবকে list of dates. Other side কে দে?
1025 is terms of settlement.
Yes.
Terms
of settlement. Kindly take the terms of settlement at page 1025.
May I come back? We will take time sometime.
Man, all the seniors on the other side are abandoning me. And leaving Mr. Dhar, the real mischievous one. Now, will it kindly take the terms of settlement, which your lordship will find at 1025. Well, your lordship will find the parties of the kindly take the signatures. Now, this is so important. Kindly take the signature on the right hand, near the right hand side of the page. Laterally signed, your lordship will find Debashish Chaudhary for Sanket Merchandise Private Limited. Maharaj got that? One Debashish Chaudhary, director, authorized signatory. So, now your lordship will find what are the terms of settlement. The parties of the first part, these terms of settlement were entered into on or about. The negotiation started on or about September 24, 25, 2023. Draft terms of settlement, my lord, were prepared and finalized on September 28, 2023. And my lord, then the terms of settlement agreement was entered into on October 16, 2023, which I am taking your lordship to that document. The list of dates, your lordship will find all the dates. Now, my lord, your lordship will find parties of the first part do hereby declare and affirm that they do not have any right or title or interest or claim whatsoever in nature in respect of any portion of land comprising in the plots of land as more fully described and detailed in Schedule B. The parties of the first part do hereby declare and affirm the following registered instruments shall stand cancelled. So, these deeds would stand cancelled, and they were in fact cancelled in terms of the terms of settlement. Now, my lord, then pending litigations, kindly to come to page 1026. III.
1027.
26. The next page, my lord. Pending litigations as more fully and particularly described and detailed in Schedule C hereto shall be decreed on compromise based on these terms of settlement. In this connection, the plaintiffs and defendants in the litigations mentioned in Schedule C who are parties herein shall file joint compromise petition annexing these terms of settlement, seeking compromise decree based on these terms of settlement in the litigation mentioned in Schedule C, and these terms of settlement shall be part of the compromise decree. The parties as well as their legal heirs and or representations shall never challenge or reopen the disputes relating to the litigations mentioned in Schedule C. Then, my lord, kindly take Schedule C for once. Your lordship will find the
Schedule C at page.
Schedule C is at page, my lord. (1039). These are the pending litigations. Your lordship will find 17 such suits and about 12, my lord, original application before the West Bengal Land Reforms and Tenancy Tribunal. That is Schedule D, Schedule C, and Schedule B. Well, it gives the details of the plots in question. Plots of land in dispute. So all settled. Now, my lord,
দেখাবো আমরা কোথায় হয়েছে
yes, আমি আসছি দাঁড়াও।
all revisional application everything has been withdrawn
Everything with
মাসগুলো দেখাও
kindly take now, my lord, along with this, kindly take page 2.
চিটিংবাজি কোন জায়গায় নিয়ে গেছে সেটা কোর্টকে দেখায়
Kindly take, my lord, the written objection which we filed pursuant to the leave granted by the this honorable court in তো দেখাচ্ছি
সব ক্লাসগুলো দেখায়
অ্যাকশন টেকেনটা দেখাবো।
আপনারা বল
আছি আছি, কোনো চিন্তা করো না, আছি।
তোরাই বলবি তুই এরকম করছিস কেন?
Kindly take, my lord, take page 255 for your lordship's kind consideration. 255, which is, my lord, this written objection, where we have indicated how the compliances have been effected in accordance with the terms of settlement clause wise. But this is very vital. I will indicate that. So this is part of my written objection, and the learned trial judge was required to consider this at the time of passing this order, impugned order. My lord, details of condition, parties of the first part do hereby declare and affirm that they do not have any right, title, or interest or claim whatsoever in nature in respect of any portion or parcel of land comprised in the plots of land as more fully and particularly described in the detailed schedule hereby. The parties have complied by putting their signatures in terms of settlement. II, the parties of the first part do hereby declare and affirm that the following registered instrument shall stand cancelled and declared as null and void. Now, my lord, now there are several deeds which are indicated from page 256 to 257, 260, which were there in the compromise petition, I mean the terms of settlement. Now, my lord, kindly take 255, details of compliance. 256, the parties of the first part have handed over the original of the deeds as mentioned in the serial number IIA and yes, IIA to IIL, and all such deeds have been cancelled by the appropriate authority. Photocopy of the certificate.
IIA to IIL where?
My lord, kindly your lordship would have to take then page 1025. If your lordship kindly keeps 1025 side by side, your lordship will find that the terms of settlement provide for this kind of 1025 is the terms of settlement.
Yes.
Kindly take, my lord, just 1 minute. Yes. Kindly take IIA. My lord, your lordship has got at page 1025 itself. These are the deeds which were required to be cancelled in accordance with the terms of settlement. My lord, the terms of settlement itself records that these deeds have been cancelled. in accordance with the terms so provided for, and joint compromise petition being filed and compromise decree being passed. Before I take your lordship to the other compliances, kindly take your, would your lordship kindly take the joint compromise petition, annexed to which is the terms of settlement. Kindly take the joint compromise petition, starts at না আরেকটা জায়গাও আছে, এখানেও আছে 1014 it starts. Kindly take, yes, 1021 একটা ভলিউমে সুবিধা হবে না যশ সাহেবের. Kindly take, your lordship will find there are two affidavits, one by Debashish Chaudhary, that is as 1023, and the second one by Supriya Mukherjee. So Debashish Chaudhary would be for the plaintiff and Supriya Mukherjee would be for the defendants, because Supriya Mukherjee had the authority to sign on behalf of all the defendants. That is not disputed. Now, my lord, your lordship has found that the deeds are provided for. Now, kindly come to the next clause. Kindly take page 260.
Page
260, 260. From page, from page 256 to 260 are the details of the deeds which are required to be cancelled, which were required to be cancelled, and which have been cancelled in due course.
এটা একবার দেখাবে 258 এ যে দুটো ডিট নিয়ে ও কনসার্ন সে দুটো ক্যান্সেল।
My lord, your lordship will find there are two deeds. One is deed number F and one is another is deed number G and H. One at 258 and another at 259. Well, these are the two deeds, my lord, which were the subject matter of the suit being TS 562 of 2023. Out of which, my lord, this application has now been filed. Now, my lord, kindly along with this, kindly take the next clause, that is 260 III, my lord, serial number III in the table. The pending litigations as more fully described and particularly described in Schedule C hereto and shall be decreed on the basis of compromise based on the terms of settlement. In this connection, the plaintiffs and the defendants in the litigations mentioned in Schedule C who are parties herein shall file joint compromise petition annexing the terms of settlement and terms of settlement in the so and so. Well, the compliance is like this. Well, the parties or signatories of the terms of settlement, including the plaintiff, have complied with this condition by filing compromise application in all title suits mentioned in Schedule C of the terms of settlement by getting title suits decreed on compromise. The civil division application mentioned in Schedule C to the terms of settlement, the terms of settlement was also withdrawn from the Honorable High Court. No other party or signatories to the terms of settlement have questioned the compromise or have challenged the said compromise degree till date. It is the plaintiff. Then, my lord, our contentions are there. So, my lord, 16 suits and 1 CO pending before this honorable court. Stood withdrawn. Then, my lord, the fourth clause, that is with respect to one Raja Gopal Das, shall execute and register a deed of conveyance in favor of today's DEFCON. That is also complied.
মানে একটা থার্ড পার্টি সে দলিলও করেছে কম্প্রোমাইজ।
Then fifth clause, that is Sanket Merchandise Private Limited, that is the plaintiff before the learned trial judge, being one of the parties of the first part, shall take immediate steps for deletion of LR Khotiar number so and so under Mouza Barhan.
These are parts of your written objection to their 151 application.
Yes, 151.
all points
Everything acted in accordance with the terms of the settlement. My lord, the compromise petition clearly indicates that the terms, everybody is abandoning us. I think your lordship is from CPM as original side.
You can continue, not a problem.
So, my lord, now may I just indicate to your lordship? So, in that view of the matter, your lordship will find that the terms being acted upon. Now, my lord, kindly take the next one, the terms of settlement. May I take your lordship back to the terms of settlement? Yes. The other part of terms of settlement that on the basis kindly, if your lordship kindly takes page 1027.
1027.
Right. That is part of the terms of settlement, starts at 1025 being annexed to the joint compromise petition, which starts at page 1021.
102.
But your lordship will find,
1027, yes.
yes, your lordship will find that, my lord, that the complaint lodged by Prosenjit Ganguly so and so, director of MJM so and so, my lord, case was registered, my lord, steps would be taken to, my lord, for, my lord, cooperating in the investigation and everything. 10. এটা কি আচ্ছা এটা ছাড়ো, এটা দরকার নেই। Now my lord, kindly take what is relevant is 11. Suleiman Salim তো এটাই তো 11, that after filing of joint compromise petition as referred to in clause III above and hearing of the application in presence of the plaintiff and defendant before the concerned civil court, the compromise affidavits, compromise petition and compromise letters signed by the complainant in electronic complex number so and declaration given by the second part shall be handed over to Sheikh Salim Rahman, advocate someone son of such and such. All such documents shall remain in the custody of the learned advocate and shall only be completely, this is stranger to the entire terms of settlement. It's a third party. He is in no way involved. So we picked up a neutral a party to take custody of the relevant papers. Shall be addressed and filed the concerned police station, and after pending litigations described in Schedule C are decreed on compromise basis by order of the concerned civil court. The informant complainant of electronic so and PS complex case numbers shall remain present, cooperate with the FIR named accused person and the associate at the time of filing compromise letters or compromise affidavits before the concerned police station. So the lordship will find, my lord, there were litigations are to be settled, deeds are to be cancelled, including the development agreement, which formed the basically was caught in the eye of storm. In the sense, my lord, it was our allegation that the development agreement was a forged document. So all these were settled, acted upon. Then, my lord, what happened is very interesting. Then, my lord, kindly take what happened thereafter. When they filed this application under section 151, kindly take their application under section 151, which is at page 104.
হচ্ছে যে দেবাশিস চৌধুরী সই করেছে, যে দলিত করেছে
104.
Yes. Kindly take from, my lord, it starts at basically at page 111. What is the basis of this recalling application under section 151?
111.
111.
Yes.
Well, after same set of lawyers, that I will establish. I'm bole diyechi already. It's the same legal team.
সেম লয়ার উইথড্র করছে, সেটেল করাচ্ছে।
Now, my lord, kindly take, my lord. Paragraph 7. The plaintiff states that as the then authorized representative, Mr. Devashish Chaudhuri, submitted his resignation on 30/9/2023 for his personal reasons immediately after the institution of the suit, which having been accepted and forwarded to ROC for necessary changes. That thereafter, plaintiff engaged one Shibram Mojumdar As its authorized representative, the newly appointed constituted attorney was not much aware of this court proceeding because it was a very hard and embarrassing task for him to come to know about the status of the present suit. Be it mentioned here that thereafter, it became a regular task for the plaintiff's directors and staff to go on asking the said Debashish Chaudhary about the case. But he on each and every occasion tried to take time on several pretexts without giving any cogent answers. Consequently, the plaintiff appointed Shonjit Jha, one of its staff, as its authorized representative on 21/6/2024. That the plaintiff states the plaintiff has been desirous of developing the suit properties. These are the other contentions. Kindly come now to paragraph 14. That coming to know that the same, the plaintiff through their newly appointed advocate applied for certified copies on 3/12/2024. On perusal of the same, revealed that on 18/10/2023, a joint compromise application was filed in connection with this suit before the learned judge in charge, and on the basis of the same, the learned judge in charge was pleased to decree the suit in terms of the compromise application. A perusal of the same compromise application as well as those certified copies was nothing but a round of painful surprise for the plaintiff, and as a matter of fact, a serious fraud has been practiced not only upon the plaintiff but also upon the learned court to destroy the plaintiff's property rights in respect of the suit property. Having left with no other alternatives, the plaintiff's directors personally met the said Debashish Chaudhary, and from him they came to know that PS Group, in collusion with the defendants, immediately after getting the news of injunction, started imposing tremendous pressure upon him through extremely powerful political leaders, as well as falsely incriminating him in some cases for withdrawing the suit, followed by a specific threat of suffering from dire consequences in the event of his refusal to do the same. Now, the grounds are stated, and he prays for recalling of the said decree at the prayers your lordship will find at page 126. But strangely enough, your lordship will find that, kindly now take some of the, kindly come back, your lordship has the list of dates with your lordship. Kindly come to some of the dates. This is so important. Your lordship will find, kindly take the date September, some of the relevant dates would be September 24, 25. The parties entered into negotiations with their learned through their learned advocates for possible settlement. September 27, draft terms of settlement was prepared. September 30, 2023, but this was never made known to the defendant, that Debashish Chaudhary allegedly resigned from the post of director of OP number 1. The petitioner was not made known about such resignation. It's a fact that this fact cannot be disputed by any of the parties. This resignation letter or email, your lordship will find at page 205, which is at volume 2. Then, my lord, if your lordship kindly takes the volume 2 for once. I'm troubling your lordship. There's so many volumes. I'm so sorry, my lord.
Volume 2.
Volume 2.
Yes, volume 2.
Your lordship may kindly take page 205. This is the purported resignation letter written by Debashish Chaudhary to the plaintiff.
205.
205. 206. My lord, this is the acceptance of the resignation by the plaintiff. This is dated October 10, 2023. That is, my lord, 3rd October.
06.
October 3, 2020. Sorry, October 3. Then, my lord, this service request was made before, my lord, change in the director, the change in the position of status of directors on November 23, 2023, which is at page 207.
At page 208, okay? A resignation at date.
Yes.
একই তো ডেট হবে, ঠিক আছে, that doesn't matter. Now, my lord, in this connection, the lordship kindly takes. So one thing is very clear, even if it is assumed for the sake of argument that the resignation was made, submitted. But this resignation does not divest Debashish Chaudhuri of being an authorized signatory in the suit. Admittedly, my lord, if we take the pleadings made in the application, Dana.
Authorized signatory, yes.
Yes. Well, he was an authorized signatory, and he remained an authorized signatory. In fact, your lordship would be astonished to take note of the fact that even after my lord, this tendering of resignation, so-called, my lord, when they started acting in breach of the terms of settlement, applications for mutations were filed on behalf of the plaintiff by Debashish Chaudhuri. And that would be
Application for
mutation. My lord, they were not supposed to file mutation applications because it was settled that these lands belong to me. Because they cannot take advantage of the development agreement, which is part of the terms of settlement, which stood cancelled. Now, my lord, kindly take those two documents straight away.
yes.
Kindly take, my lord. Your lordship will find the mutation applications at the mutation application will be short code. Just my lord, kindly give me a second. 828.
Page volume 6.
828.
Yes. List of dates কোথায় আছে বলো?
The list of dates আছে
Dates টা বলো, dates.
20th September 2024.
Kindly take the date 20th September 2024. Two documents, one at page 828. I'm sorry, my lord. Another at page 832.
828.
Your lordship will find this is an application on behalf of Sanket Merchandise, 828, my lord. I'm so sorry, my lord. Application on behalf of Sanket Merchandise, Private Limited.
828 and 832.
Well, all the compliances were effected on or before the end of March 2024. So after basically 6 months, yes, 6 months.
Eight 32, yes.
They were encouraged to, my lord, to undertake this kind of exercise simply because, my lord, with our cooperation, as we cooperated in terms of settlement, the criminal complaint lodged by us, my lord, it ended in an FRMF. Before that was, my lord, just prior to that FRMF, my lord, this final report in mistake of fact, my lord, they engaged in this kind of activity by making application for mutation. Kindly take, my lord, 828, kindly take the application date. Your lordship will have Sanket Merchandise. Right, Sanket Merchandise. Who is the authorized signatory, my lord? I put the question to myself. It is Debashish Chaudhuri. That is nearly, my lord, after 9 months, 10 months from the date of the compromise decree. Yes, sorry, 11 months. 18th October compromise decree was passed. All the compliances were effected on or before March 2024. On September 20, 2024, my lord, they make an application for mutation. in terms of, my lord, in complete breach of the terms of settlement. The declaration form your lordship will find for this mutation application at page 832. My lord has got that?
Yes.
Now, my lord, along with this, kindly
Yes.
your lordship will find from the this application for this application under section 151. হ্যাঁ, ওটা তো সংকেত করেছে, ওটা একটা প্যারাগ্রাফ আছে, ওই শিবরাম মজুমদারকে কবে করলো, কাইন্ডলি টেক প্যারাগ্রাফ 8 of one of the at 116, that is the volume 1, that is the application under section 151.
Volume 1.
Yes. This is extremely important.
Volume 1, page 151.
Yes. 116.
116.
Well, this part of the 151 application. May I read it out? That thereafter, the plaintiff engaged one Shibram Mojumdar as his authorized representative. Since the newly appointed constituted attorney was not much aware of the court proceeding, it became a very hard and embarrassing task for him to come to know about the status of the present suit. Be it mentioned here that thereafter it became a regular task for the plaintiff's directors and staff to go and asking the said Devashish Chaudhary about the case. He on every occasion tried to take time on some pretext or several pretexts without giving any cogent answer. Consequently, the plaintiff appointed Shonjit Jha, one of its staff, as his authorized representative to proceed with the suit on 21/6/2024. So, my lord, till 21/6/2024, there was no formal withdrawal. Even if we take the amendments to be correct on its face value, there was no formal change of authorized representative. Even otherwise, if we take the date of 21st June 2024, my lord, as a date which would govern the next stage of proceedings, your lordship will find from pages 828 and 832, it is that said Devashish Chaudhary who is again making application as the authorized signatory on behalf of the company before the BLLR. So, your lordship, my respectful submission before your lordship would be that this.
What has the learned trial court done? He has decided the application under 151?
He has done something great. Kindly come to the impugned order. Because, madam, I have given your lordship the brief overview of the facts. I will take your lordship through the impugned order. Kindly come to the impugned order. কটা জায়গায় রেখেছিস? আমি কোনটায় নোট করেছি দেখিনি?
Yes, impugned order.
আমি এটাই নোট করেছি 45 পেজ 45 মানে কি? Page 45, my lord.
Impugned order is the certified copy.
Certified copy. Kindly take, my lord. When I am placing from third paragraph. Fourth paragraph. The learned advocate for the plaintiff company submitted that the suit had been filed by the plaintiff company for declaration injunction against the defendants, but without the knowledge or consent of the plaintiff company, one of its directors, namely Devashish Chaudhary, filed an application for joint compromise, and as such, the said compromise application was allowed by this court video order dated 18th of October 2023. Accordingly, a compromise decree was drawn by this court, video order dated 23/11/2023, but by filing this petition on 21/12/2024, the plaintiff company contended that the alleged settlement compromise is visited by fraud as well as malafidness, as the said Devashish Chaudhary was not authorized by the plaintiff company for any type of compromise or settlement. Rather, said Devashish Chaudhary was removed from his post prior to the date of the said compromise or settlement. It was not removal, it was resignation. It was their own case. Thereafter, therefore, he had no capacity or authority to represent the plaintiff company on the day of alleged settlement or compromise. Thus, this petition dated 21/12/2024 has been filed by the plaintiff company under section 151 of the code for restoration of the impugned suit in its original form by its order number so and so dated after hearing the plaintiff company they allowed them, and this gives the genesis of the present proceedings. Kindly take the second paragraph at the next page, the internal page 2. During hearing or rehearing, the main point of contention of the learned advocates for defendant is that the court has no power or authority to restore the impugned suit to its original form by setting aside impugned compromise, settlement or judgment and decree on the basis of petition under section 151 of CPC on the ground of alleged fraud committed by the said Debashish Choudhury. In other words, this court has no inherent power under section 151 to set aside the impugned compromise or settlement judgment and decree on the ground of alleged fraud. The proper course left to the aggrieved party is to file an appeal to set aside the impugned compromise judgment and decree. This court has no jurisdiction to set aside the impugned compromise judgment and decree under section 151 of CPC on the ground of alleged fraud. No such power or authority vested with this court under section 151 of CPC. Thus, the impugned order number so and so dated 21/12/2024 has no legs to stand and should be recalled or altered or modified. Per contra, learned advocate for the plaintiff company submitted that this court has jurisdiction to set aside a compromise decree on an application under section 151 of CPC on the ground of alleged fraud as well as malafidness. As per the plaintiff company, this court being the court which had passed the impugned order number so and so dated 18th October 2023 has jurisdiction to hear a petition under section 151 of the Code of Civil Procedure for setting compromise decree for setting aside, it should be, compromise decree on ground of fraud and has authority to set aside the same. Hence, the impugned order number 6 is perfectly proper one and there is no need to alter the recall the modified impugned order dated so and so. Considered. On perusal of record, it appears that the plaintiff has filed the suit against the defendants for declaration and permanent injunction. Subsequently, a compromise judgment and decree were passed by this court on an application filed by the parties of this suit. Video order number so and so dated 18th October 2023, order number so and so dated 23/11/2023 respectively. The being aggrieved and dissatisfied with the order dated 18th October 23 and 23rd November 23, the plaintiff company approached this court by filing an application under section 151 of CPC on the ground of alleged settlement or compromise is visited by fraud as well as malafidness. As said, Debashish Choudhury was not authorized by the plaintiff company for any type of compromise or settlement. Rather, he was removed from the post prior to the date of said compromise or settlement. It was also contention of the plaintiff company that the said Debashish Choudhury had no capacity or authority to represent the plaintiff company on the day of alleged settlement or compromise, and as such, this petition under section 151 CPC has been filed by plaintiff company for restoration of the impugned suit in its original form by its order dated so and so dated 21/12/24. After hearing the plaintiff company, the court below, this court allowed the impugned petition under section 151 dated 21/12/24 and restored the impugned suit in its original form. But the defendants contended that this court has no inherent power under section 151 of the CPC to set aside the impugned compromise or settlement judgment decree on the ground of alleged fraud. The proper course would be to file.
Decided anything as yet.
Malad, he has not, Malad, what he has done, your lordship will find, when this honorable court remanded the matter by an order dated, my lord, 24th September 2025, this honorable court was pleased to observe that you dispose of the 151 application. 20 hearings or 21 hearings later, the learned judge, with due respect to him, the learned judge, my lord, decides that it is to be registered as this 151 petition is to be registered as a missed case. And this opinion or this view is not formed on the basis of any evidence. It is simply that some allegation has been made Now, after, my lord, one part of the order I must place before your lordship, which is, my lord, I think, my lord, this what matter has to be decided here. Kindly take, after the judgments are quoted, in fact, one of the judgments say otherwise, quoted in the, my lord, in this order. Kindly take from page 4, last paragraph.
Yes.
This is the operative part. Thus, from the above mentioned facts and circumstances as well as judicial precedent as cited above, it is clear that this court has inherent power or jurisdiction to set aside a compromise decree on an application under section 151 of the Code of Civil Procedure on the ground of fraud or malafidness. The plaintiff company has rightly approached this court as this court recorded compromise and made decree in terms thereof, and as per the plaintiff company, the same was not lawful. Thus, this court which recorded compromise should consider and decide the question whether the said compromise was legal or not. But the plaintiff company of this instance has to prove. So, my lord, this is a kind of encouraging, my lord, a fishing expedition after registering the case under, say, as a miscase, under section 151 as a miscase. And what should have been done, my lord, it is like putting the cart before the horse. First, my lord, the plaintiff has to adduce at least minimal evidence, discharge the, my lord, the initial owners, and evince the honorable court that this application is otherwise maintainable and fraud was actually committed. The honorable, the learned judge says that I am now registering the case, and now you will be required to adduce evidence in support of your, in support of the case you made out in the application under section 151. But this is, my lord, your lordship will find that this kind of, this approach itself is contrary to, my lord, the directions contained in the order passed by this honorable court in the order dated 24th September 2025. This is the.
Is it your contention, Mr. Mojumdar, that the learned court is not entitled to go into evidence at this stage?
Is, my lord, the learned court, if the learned court is of the view, yes, my lord, that 151 petition is to be entertained. First, my lord, may I just formulate the points now? Because it is essential that I formulate the points. May I just formulate the points in this way?
Yes.
First is that when there are adequate provisions made, provided for in CPC, for redressal of grievances against an order, compromise decree obtained by fraud, any application under section 151 could not be entertained. In the absence,
be treated to be an application under order 23, the relevant provision.
My lord, there your lordship will find, this is very interesting. It is absolutely, my lord, it is absolutely, I'm bow down to your lordship's observation. It, my lord, either 23, 20, my lord, if we look at the scheme of the code, after the 76th amendment, kindly take the scheme of the code. The first, my lord, kindly take order 23, rule 3.
21 of the chale geche.
Oh. 23, rule 3.
25 হয়ে গেল।
Yes.
23 rule 3 provided.
Kindly take order 23, rule 3. Where the court is satisfied. Order 23, rule 3 right? Compromise of suit. Where it is proved to the satisfaction, 3A is barred.
So no separate suit?
No suit can be filed to set aside a compromise decree obtained by fraud. My lord, the key word used in, my lord, order 23, rule 3 is the agreement has to be a lawful agreement. When the expression lawful is used, and lawful would mean lawful in terms of the Indian Contract Act. So we get to the series of 15 to 20, 16 to 23 of the Contract Act. So if it is not lawful, well, it is for the plaintiff or the party,
whoever feels aggrieved,
whoever feels aggrieved, to establish before the court, discharge the initial owners by applying, in view of the principle of onus probandi, that yes, fraud has been committed, not mere statement would do. Secondly, my lord, if we take this provision, if we, my lord, two things could have been done. Along with this, my lord, kindly take Order 43, Rule 1, capital A. Order 43, Rule 1, capital A.
Just a minute.
This is one of my contention. But it is not a case where, my lord, a mere reference to a wrong provision has been made and the court is condoning such act. It is a decision taken by the learned judge that yes, 151 application is maintainable. Whether convertible or not, that's not the question. It was never argued by, my lord, the plaintiff before the learned judge that yes, you can take it as an application in terms of explanation to section order 23, Rule 3. It is not so. This is a case where the learned judge proceeds on the basis the no, yes, no, 151 is maintainable. Kindly take Order 43, Rule 3, Rule 1, capital A. Because obviously, I cannot trouble your lordship. These facts were, I laid out the facts just for the sake of, completeness. Your lordship would not be deciding that. I understand that. But kindly take, my lord, for once, Order 43, Rule 1, capital A, 1A. Right to challenge non-appealable orders in appeal against decrees. Kindly take Order 41, Rule 1A, Sub-Rule 2. In an appeal against a decree passed in a suit after recording a compromise or refusing to record a compromise, it shall be open to the appellant to contest the decree on the ground that the compromise should or should not have been recorded. So, this is a kind of cure-all, catch-all provision, which embraces in itself even the act of commission of fraud. Even otherwise, if an application had to be made before the learned trial judge, that application had to be made having regard to the provisions contained in Order 23, Rule 3 explanation.
Its application of Order 23 is at the stage when the compromise is put forward.
And my lord, when my lord, this Order 23, Rule 3 application could be preferred, it is only at the stage when the compromise is being put forward, not at a subsequent stage. So, my lord, suit is now barred under Rule 3, capital A of Order 23. But the specific provision has now been made for challenging, my lord, any compromise decree for, my lord, on the ground that compromise ought not to have been recorded. So the remedy which is available is, my lord, Order 43, Rule 1, capital A.
It's not a void one order.
My lord, this is a question where, my lord, the court would be examining. My lord, obviously the appeal court, had the appeal been carried to the appellate court, first appellate court, the first appellate court would be examining that whether, my lord, the gentleman was competent to, my lord, to sign the joint compromise petition, to sign the terms of settlement, and if he was incompetent at all, fraud has been committed by the defendant upon the plaintiff or the court, because it is not my representative. From 3rd October 2023 till December 2024, there is not a single correspondence made by the plaintiff addressed to the defendant that I have changed my authorized representative. He may have resigned as a director, but I am not inviting. Why I am submitting this, that this issue could have been decided by the first appellate court. But pausing here for a moment, directly, a judgment rendered by the Honorable Supreme Court, my palace টা আছে কালকে যেটা দিয়েছি 2022, আমার কাছে আছে জজ সাহেবকে দাও, kindly take this judgment. দিচ্ছি দেবো। Kindly take, my lord, paragraph 28. This is 2022 19 SCC 806, paragraph 28. May I place, my lord?
Yes.
Section 151 CPC can only be applicable if there is no alternative remedy available in accordance with the existing provisions of law. Such inherent power cannot override statutory prohibitions or create remedies which are not contemplated under the code. Section 1.
Mr. Majumdar, this is settled.
This is settled. Kindly note the paragraphs. 28.
Sharia generalibus
Yes, yes,
non-derogable.
yes.
There is a special
28, 35, 36. But the next proposition of law which I am trying to make before Lordship is that, as I indicated, in the present case, the application has not been styled as an application under Order 23, Rule 3. Expansion.
It's all substance over form. If in
Malad,
substance,
Malad, I understand, Malad. Malad, what has fallen from my lord, I understand. But my submission would be that it is all substance over form. This principle would apply in case where, my lord, the parties recognize that substance should take over the form.
Even if the parties do not
and
recognize,
the court has to then decide.
The court,
The court held.
If the ultimate conclusion, Mr. Majumdar, boils down to it that it is maintainable not as an application under section 151, but maybe as an application in under the proviso to Order 23, Rule 3.
But proviso will not apply, my lord. Proviso, kindly take proviso for once. Proviso cannot apply in this case. Perhaps I have not been able to make myself clear. Kindly take proviso.
Yes.
The stage of proviso is no longer available to them. Provided that where it is alleged by one party and denied by the other, that as an adjustment or satisfaction.
This is before the compromise.
Yes, before the compromise.
No, but there is a judgment of the Honorable Supreme Court, which I am aware of, where the Honorable Supreme Court has said that you cannot file a suit, you have to approach the same
No,
court.
suit cannot be filed because of the bar under 3A.
Then you have to approach the same court is what the Honorable Supreme Court has said. Reading this 3A bar.
But then, my lord, the question is that the party can, that application can be taken out if the party could not present itself, or if party was not put on notice that this kind of application has
No,
been
that
moved.
was not the case. It was said that if you are aggrieved, still you have to approach the court.
Then, my lord, if we take, my lord,
It was Justice Ravindran's judgment, I remember, much
earlier. 2008-9.
I
Justice
had
Ravindran
an
is
occasion to go through
2006 to 8-9.
I had in one of the cases used it.
Then, my lord, the question arises that what is the order which we are challenging before lordship? We are challenging an order where the learned judge decides that yes, 151 is only maintainable. The learned judge doesn't say that this can be regarded.
But if there is no provision under which the learned judge can be approached.
The provision is there. The appellate provision is there.
No, but the Honorable Supreme Court has read that, saying
Yes.
that I am not being able to recall the exact, but I can say that it was Justice Ravindran's judgment.
Just 1 minute, my lord. Kindly give me. Kindly take, my lord, procedural safeguards. My lord, kindly take for once paragraph 35 of the judgment which I placed. Perhaps, my lord, it will be an answer to your lordship's query. It may be an answer to your lordship's query. The High Court relying upon, my lord has got 35. The High Court relying upon above judgments of this court, which recognizes the power to recall, seems to have lost sight of the restrictions imposed while exercising jurisdiction under 151 CPC, which were elaborately discussed by this court in the above referred judgment about exercising the power under section 151 CPC being only in circumstances where alternative remedies do not exist. Therefore, we are of the firm opinion that recalling a final decree in such circumstances cannot be countenanced under section 151 CPC. The High Court erred in exercising its jurisdiction under section 151 CPC to hear and pass a detailed judgment.
How would you address the section 96(2) bar vis-a-vis order 43 rule 1A?
Well, 96(3). Your lordship is referring to 96.
Consent decree bar.
Consent decree bar. your lordship will, the provisions would have to be reconciled.
That is
In
not
the sense, kindly take 96.3. The lordship is referring to 96.3, I suppose.
Yes.
Subject to correction. No appeal shall lie from a decree passed
on consent.
with the consent of the parties. Malad, this one is consent. Kindly now take the language used in 43. Or appeal will lie. One has been inserted, right to challenge non-appealable orders in appeal against decrees. 2. In an appeal against a decree passed in a suit, after recording a compromise or refusing to record a compromise.
First appeal.
Yes.
That is the first appeal. Appeal from original decree.
But this is an original decree.
First appeal.
This is the first appeal, and this is an order. This is an order. The compromise decree. না কেন ফার্স্ট অ্যাপিল তো একই তো
হ্যাঁ কিন্তু ওটা ফার্স্ট মিসেলেনিয়াস অ্যাপিল হবে 43
challenge
43 1 এ will be my lord first miscellaneous appeal.
Mr. Chakravarti will again read this in the light of what I say. Maybe I am wrong.
Yes.
Once you challenge the compromise decree saying that the decree is fraudulently obtained,
right,
in terms of Order 43 Rule 1,
right,
that will be a decree only. You are not challenging the order.
It's a decree. It's a let us take the language of 96.3.
You want to differentiate between consent and compromise.
I want to differentiate on different. One is consent by the parties, another is recording compromise, where my lord terms of settlement are arrived at.
It may require a little more reconsideration.
Because my lord, then my lord, otherwise,
because
Order 43 1.
Order 43, as we all know, is only about orders.
Yes.
Once
Appealable orders.
Yes, appealable orders.
Right.
Orders which do not amount to decree.
Right.
Where the provision for appeal is provided for those orders which are otherwise not appealable. Those are the only orders which are appealable.
Right.
Now, when we talk about a decree, we are not talking about orders. Now, what is under attack is a decree of compromise. Decree on compromise.
And Rule 1 capital A takes note. Kindly take the language.
Yes, Rule 1 capital A is, in a sense, extension of say 105.
Yes. Absolutely.
100 extension of 105.
Right.
Where what you could have challenged have not challenged.
Right.
You will be entitled to challenge because the decree is in entirety before the appellate court.
Yes.
So all interlocutory things are also there.
May I just explain it in this way? Whatever I have understood. My lord, what is challenged, what can be challenged in Order 43 Rule 1A is, my lord, the factum of consent and not the content of consent. The factum of consent is, my lord, when one of the parties alleges that yes, the authorized signatory was not my authorized signatory. It is all about factum of consent. My lord, may I use the language which the Supreme Court often uses in one of the judgments? Kindly take, my lord.
But you, Mr. Mojumdar, please look for that judgment of Justice Ravindran.
I will look. This is one limb of my submission. The second limb of my submission.
Go before the same.
I understand, my lord. This is one limb of my submission. The second limb of my submission would be, even if it is assumed, for the sake of argument, that this application is maintainable. My lord, even if it is assumed that this is maintainable, then, my lord,
and you take this point before the learned trial court.
We had taken this point. This point was taken. This point was discussed, not addressed to. We had also taken the. We had also taken the point that the compromise decree has been acted upon. In my written objection,
merits. The compromise decree has been acted upon will be a point on merits, whether this application per se is maintainable or not because of it not being.
right.
That is
No,
another
my lord,
point.
kindly, my lord, kindly do not send me back for another 20 days of hearing.
That
My
will
lord,
be, that will be confined.
my lord, my lord, this was the exact direction given by the by this honorable court. My lord, unfortunately enough, my lord, we were unable to get the matter heard. My lord, whatever has happened,
something which has not been
I
decided.
tell you, lordship, my lord, I am told. My lord, I am telling you, I am making this submission before your lordship. We have got all the orders for these 20 dates or 21 dates. It would show that every day when this matter is taken up, these matters are generally taken up in the second half because it's a hearing matter. Naturally, it will be second half. Every day when this matter was taken up, every day on some pretext or the other, either the court will not sit, either, my lord, somebody has to attend. But every day, my lord, the learned counsel, the legal team appearing for the plaintiff is so powerful out there. It is very difficult to get the matter heard out.
No, he will get a resolution at 2:30 so that the matter is not taken up.
Mr. Chakraborty personally attended all the hearings. My lord, for 20 days he appeared. And my lord, Mr. Chakraborty can say what is happening out there.
It is impossible to work in Baruipur by a sane person. I take it, we tell this with responsibility. This gentleman who runs the entire bar, entire court, he decides what is to be done. At 2:30, when the matter is to be taken up, he says, after his interlocutory applications are done, he immediately takes up a resolution, stops the court. Every day, football match, Shraddho, Janmodin, Annaprasan, Gudi Orano, Vishwakarma Puja, every day.
My lord, I will come. My lord, I will come to that. My lord, would your lordship kindly take it up on Thursday, my lord? Kindly take it up on Thursday.
Main person who
Kindly, my lord,
this Thursday will be difficult because
Friday,
this Thursday I'll be having.
Friday, my lord. Friday, Monday, Monday, not Tuesday. But my lord, the test is, my lord, as I attending.
20 বছর আগে শতাংশ বাচকের ফর্মে দেখতাম, এখন আর দেখতে পাই না। 10:30টাও পারে না করতে,
কিচ্ছু পারে না।
হ্যাঁ,
সেই জিনিসই নেই শতাংশটার মধ্যে। Second September.
এই মামলায় কত বলবি আর?
বলবো আমরা শেষ করে দেবো। Second September.
Converted to suit court.
No, I did not make any submissions, my lord. I did not convert this into suit court, this honorable court.
Point is whether the compromise has been signed by all the parties. Answer is no.
On merits. He said
That is on merit. I am on a different.
At best, I will convert to appeal.
At best, converted to appeal. Then, my lord,
Contention is accepted. I will be converted to appeal.
it cannot be converted to appeal. This application then has to go. This cannot be converted into appeal.
This compromise decree cannot be
Mala, I am extremely grateful to Mr. Basu.
very well. When can we have it?
Mala, some early second September next week. Next week.
2nd September is the next week,
2nd September.
2 p.m.
Ki aaj
Next
second.
Wednesday, 2nd September.
We will make ourselves. Well, only questions of law I will argue.
Let it be there.
Ki abar korbe?
Uncertainty আছে।
2nd September কিসের uncertainty?
আমার uncertainty। সেটা থাকতে পারবে না।
My lord recollects 20, 25 years back when we all entered. How long we will work? Now he has lost the capability.
The distinction has to be drawn between factum of consent and reality of consent. That is why, my lord, compromise and consent in 2 days.
I'll also think over it.
After 1986 amendment, it is there.
May I take your
2% can compromise. Then, my lord, I need not appear in court.
You act upon the compromise, accept it, then say it is not done.
Heard Mr.
হ্যাঁ,
My lord, item number 25, Possibly an order in item number 10 will be required. My learned friend
Yes,
is here.
passed over একটা call করে দিন।
Item number
Minor item number 25.
এটা নিয়ে নিন। দেখুন এই কাগজটা উড়ে যাবে। এটাও রেখে দিন। Yes.
I have taken instructions with respect to page 152. They have said that let there be a written application for them for settlement of this amount. Then they will process it to the HO, higher authority, because they are not the appropriate authority to just sanction in it in one day, but they will do it as soon as possible. Until date that auction, they will stall it for the time being.
That is your instruction.
That is my
Give
instruction.
it, I'll take it.
I don't have verbal instructions. Your lordship may
They have said they will stall it, so that you can bring a written instruction to that effect on day after tomorrow.
Yes, I can.
I'll take that on record it, and in the meantime you pursue it.
My lord, before Thursday, day after tomorrow, based on what is submitted, I'll make offer. That written instruction may come to the court, my lord, on Thursday. And my lord, I am a little apprehensive. Kindly consider, my lord, I very humbly beseech you.
Saying this.
My lord, settle number 1, paid, still I'm standing here as a debtor. Settle number 2, I paid, still I'm standing as a debtor.
Yes, because there are extensions also. Now this, if this is agreed upon by the parties, it has to be agreed by you and the bank. I cannot.
Bank gives an agreement, my lord, I pay and finish it off. 20 lakhs, qua that claim is already paid. I have to pay 1,61 lakhs. My lord, I have proof to that effect. It is lying.
I have already indicated this to the officials, your lordship, as whatever had fallen from your lordship, and this is what assurance I have got from them.
Very well, my lord. We converge on Thursday, my lord. In the meanwhile, I'll make an offer in advance.
You please and please come to the court. I am saying this as an officer of the court. Please come to the court if any action against you is initiated, because I am also submitting this in front of your lordship.
Very well, my lord. Kindly record that.
application, Lordship. Lordship, the will is dated 20th of August 2021. It's a registered will of Raj Kumar Khaitan.
Citation.
Citation, Lordship.
Nobody has consented.
Nobody has consented, Lordship. None of the legal heirs, there are no first-class legal heirs, Lordship. The second-class legal heirs stay outside the city and country also, because of which they are unavailable
This is
to
an
file
application
applications.
for grant of probate of the last will and testament dated August 28, 2021.
My sister-in-law and my brother-in-law, or my there is no one other legal heirs, my for general citation, my died on my 10th March 2020. petitioner is my lord, brother and my lord sister. My lord, no other legal heirs, my lord. Petitioner is having no.
Actually, only one legal year, mother-in-law, address is known, only general and special citation is required. Page number 5 and 6.
My lord, I am appealing for the petitioner, my lord, for issuance of special citation and general citation, my lord. One of the legal heirs of the deceased has not consented, my lord.
General or special?
General and special, my lord. My lord, at page number 6, my lord, of the petition. হ্যাঁ হ্যাঁ এই তো স্পেশালও বলা আছে বলেছি উনি হ্যাঁ 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 এ আর বি তো প্রেয়ারের পাতাটা নেই my lord, maybe there must be a mistake. আমারটাই রয়েছে কিন্তু ওনারটা কি করা থাকে আচ্ছা আচ্ছা স্কুটিনি করা থাকে
My lord, this is my application. My lord, non-contentious cause, all the legal heirs, my lord, are named in page 3, paragraph 6. And everyone has given a NOC. Property is at Rajasthan. My lord, I was praying for a dispensation of the citation because my lord, the executor as well as my lord, the beneficiary is suffering from dispensation. No, my lord, we have not made. But the only thing is, my lord, legal heirs are equal. My lord, all are annexed. All the affidavits are there.
Non-contest.
Oh,
I am for the petitioner, my lord. My lord, the petitioner is the son, my lord. Mother give consent, my lord. Only issue and citation, daughter, my lord, my lord. My lord, page 5, my lord. Paragraph, my lord, 8, my lord. I have stated, my lord. And my lord, I have also stated, my lord, the mother had give consent. General citation and special citation, my lord. Yes, my lord, give consent. Son, my lord, son is the executor, my lord. And daughter is not. Only daughter, my lord. Only daughter.
This is my petition, Your Lordship. The deceased lady, my lord, she has left 4 children, two sons and 2 daughters. One son has not given consent, Lordship, which is why I'm praying for citation. The genealogical table is at page 4. Only one son, my lord, the first named son in the table. So Joydeep Mukherjee has not given his consent. The rest have all given.
Testators, I am the sister-in-law of the testators and the elder sister to the other testator.
application for probate and also Milord affidavit of assets. Milord here, Milord the deceased died, Milord in Ramakrishna Mission Seva Pratishtha. Milord she has no one, Milord no issue and no relation. Milord husband predeceased her, Milord the executives before your lordship, Milord acquaintance, Milord through both of them are disciples of Ramakrishna Mission. And in her deathbed, she expressed her wish to, Milord, give all her belongings to Ramakrishna Mission. In the will, Milord, there was a direction, there was a mention of a bank account, Milord, at Bagbazar SBI. Now, Milord, details were not known to us. We made a prayer before this honorable court. There was an order passed seeking, Milord, identification of that bank account and opening of that locker, sorry, not account, Milord, locker, and Milord, the inventory and valuation of the inventory. Milord, it appears after all this exercise, but there is, Milord, jewelry worth about 18 lakhs and what. So that is to bring on record. And Milord, obviously, Milord, the valuation will go up. Milord, the necessary amendments. Yes, Milord, annexed. But this is annexed. Milord, my lord will get it, Milord, at page 11. 23rd May 2025. Supported. My lord, now, Milord, Lordship kindly sees, Milord, the
affidavit of assets, my lord. Pursuant to your lordship, being present, my lord, I have served. There is the affidavit of service, and my lord, the probate has already been granted. Only the bank name and address is to be amended. But my lord, today we are 20th. 20. Today we are on 25th. He is in Kolkata, my lord. This is Salt Lake's address. As your lordship. On next Monday. March. And then the affidavit of service be kept with the record.
This Devjani Roy is the attesting witness, my lord. 237, yes. My lord, it is an unregistered. Yes, my lord, that is why my lord allows my GA1, that is for reconstruction, and my lord. Very well, my lord. Through section 63 of the Indian Evidence Act, yes. 65, yes, yes. And the corresponding providence, yes. Very well, my lord, then kindly do one thing, my lord. Then, my lord, record that Ms. Devjani Roy is the attesting witness. She will come and depose, my lord, on doc. For providing these. Then, my lord, kindly grants me 2 weeks time, my lord. 10 days time, my lord. My lord, 10 days time.
14, my lord, this is my application for issuance of the 14, I beg to appear on behalf of the my lord. My lord,
My application for reissuance of the citations, my lord, on my lord, one of the legal heirs of the deceased, my lord. Now, what has happened, my lord? Initially, an order was passed for issuance of the citations, my lord. Thereafter, my lord, one citation with regard to this legal heir, my lord, came back. Because, my lord, the address, my lord, in the probate application has been mistakenly, wrongly written, my lord. What I am praying for is, my lord, if my lord kindly takes up my application, paragraph 8 at page 5. In the probate application, my lord, the address of Keka Mukherjee, one of the legal heir of the deceased, my lord.
But since I am appearing on
My
behalf,
lord, I have prayed for
since my lord, I am appearing on behalf of the alleged attesting witness, because although your lordship would see, my lord, that one of the alleged attesting witness, and my lord, citation has been again. My lord, citation has been issued against me. I am the daughter.
Perhaps he's appearing for the legal heir.
Legal heir, one of the legal heir. Yes, yes. Yes, yes.
Are you objecting to this?
Yes, my lord. My lord, let me have a copy of this petition, my lord. And no, my lord, I have not lost the copy yet. Lordship, my lord. No, Corini.
Master summon was issued.
Lord, I have citation was issued against me. My lord, I am appearing Lekha Sen. Lekha Sen. Lekha Sen.
He has received it on 8th of July 2025.
So, my lord, my client was very ill. My lord, he's 75 years
So,
of
my
old.
lord,
4 or 5 days ago, she.
The right to file caveat goes, man. That can be extended subject to your lordship discretion. My lord, we get that from my application, page number 32. Mode of this is a report of the sheriff. Page 32 at
July মাসে.
This is a report of the Mala Sheriff. On 8th day of July 2025, one postal acknowledgement receipt signed by Lekha Sen in respect of the cited party number 3. So he has received it.
2025. That liberty may be granted to me, Lord.
That is, my lord, kindly takes up my page number 5, paragraph number 8, my lord. Only one correction, my lord, that is scheme number 6. It was mentioned in the original. Oh, in original, that is, my lord. That is my page number 11. Page number 18 of my application. Yes, my lord, there is a chart, my lord, and serial number 6. The scheme number 6, it would be, my lord, scheme number 7. Yes, my lord, I know, my lord, but this has been filed. This application was filed, my lord, so, my lord, so I bow down, my lord. There is also a right, I know, my lord, but yes, I know the procedure, my lord, but one thing, my lord, if so, my lord grants, I have also prayed for correction, but without amendment, that cannot be done also. Then, my lord, may I just withdraw this? Very well, I shall file a new application. I have to file a new application, my lord. Then, my lord, grants me liberty to withdraw this application.
দিয়ে দাও না ওটা হাতে
Oblige, lord.
Lord, I would.
15, my lord, I am for the executrix, my lord, probate application, which I had sought for withdrawal. Now, my lord, your lordship's query was as to whether the court fees can be allowed to be returned, my lord. I have been able to lay my hands on 2 orders of this honorable court, come this side, where, my lord, your lordship, this honorable court has been pleased to allow not the applicant to, lordship, kindly consider, the petitioners are given liberty to withdraw the documents, including the original will. The court fees filed by the petitioner be returned to the advocate against proper receipt. My lord, your lordship, the contention, my lord, I'm trying to impress upon your lordship is that the list not being adjudicated, my lord, the court fees may be allowed to be used. There is no law. I'll cite another judgment of this honorable court again, my lord, which gives a similar relief. Now, in spite of this, my lord, if your lordship considers and your lordship is not inclined to, my lord, grant me, my lord, leave to withdraw the court fees. In that event, my lord, may I humbly press that this application be withdrawn and the necessary amendment application. Is exactly what I'm trying to do, my lord. Your lordship would consider in this case, my lord, there are 3 executrix. Only one of them have come forward and the others have not given a consent, which means, my lord, that I'll have to ultimately pray for the citations, because when 2 are not coming, out of the 3 joint executors, if 2 do not come, my lord, I'll have to, my lord, file a letters of administration. I cannot move forward with a probate application. Now, this is exactly, my lord, in this case, if your lordship, in fact, if your lordship would kindly consider the application, the the affidavit in support, paragraph 5 and 6. And if your lordship, my lord, kindly takes for that moment, my lord, the will itself, which your lordship will find at, my lord, page will is at page 16, my lord, 16. My lord, if your lordship considers the paragraph out of my wedlock, my husband late such and such, together we have 3 children, 1, 2 and 3, my lord, Seema, Swadesh and Nita, referred to as the executors of the will. Now, my lord, as such, there are 3 joint executors to the will. And in the instant case, my lord, if your lordship kindly peruses the application for grant of probate, there's only one which has come forward to this honorable court. So ultimately, my lord, I would have to, my lord, withdraw this and file a letters of administration. A change brief, my lord, something which has been filed, I cannot now, my lord, alter, except, my lord, amendment will be a uphill task. Monday, my lord. Kindly do not take me amiss, my lord. I'm trying to My lord, I am obliged. My
Well, this is my application for inventory of the locker. So I have set out, said the disease has a locker at SBI Salt Lake branch. She has 2 years. One has filed an application for LA and other has given consent. The second brother is staying in Australia. He has given consent. It is with the PLM. It is opened by the bank manager. He will make an inventory and list. Then we will amend the. Yes, State Bank of India.
Succession is a prayer area.
All consent is there. Your Lordship sees the list of legal heirs at page 3. Starting from page 3, earlier there was an error. Mr. Gargi Shah was thereafter included after the amendment. And all the consent have been filed before this court. The age of the minor, my lord, no, just a second. No, my lord. No, one is 14 years. No, my lord. The mother has given consent because they are minors, so the mother has given consent on behalf of both of them. No, no, my lord, there is no conflict of interest. No, the will does not say about the minors. It only says that I have bequeathed in favor of my wife. Anyway, the minors are residing with their mother. My lord, my senior, my lord. Well, every court is having the same problem.
Your Lordship, this is my application for grant of letters of administration, Your Lordship. By an earlier order dated 4th of December 2025, general citation was issued. In terms of the order, Your Lordship, the general citation was affixed in 3 places as was directed. Paper publication has been made in two newspapers, Your Lordship. And we've already filed the affidavit in service after compliance of all the directions. No legal heirs, Your Lordship. The testatrix's husband predeceased her. She had a brother and a sister, both unmarried, both predeceased her, Your Lordship. Your Lordship, the executor passed away on February 27, 2023. And I am the beneficiary under the will, Your Lordship.
How much would I? Okay, I leave it to it.
Application for grant of the probate, my lord. Your son is the executor, my lord. The other legal heirs have also given their no consent, no objection, my lord. Your execution of the will has been proved by one of the attesting witness as well, my lord. Lord, I have stated, my lord, that the mother of the testator has predeceased him, my lord.
May it please your lordship. This is my petition seeking probate of the last will and testament of Anil Kumar Jhunjhunwala. Lord, the death certificate is at page 11. He passed away on 29th December 2018. And my lord, the will is at page 12. Yes, ma'am. Yes. He passed away on 29th December 2018. He passed away as a bachelor. So his legal heirs, if your lordship sees the first few pages, there's a genealogical table. His legal heirs were, his mother and father had predeceased him as a bachelor. My lord, the wife, page 3. Page 3 of my petition, my lord. Lakshmi Devi Jhunjhunwala was 21 though. 21. Jhunjhunwala. I mix up হয়ে গেছে হয়তো। This is PLA 433 of 2000. Oh. So, I filed a nahi. Acha, acha. Very well. I'll come back, my lord. I was going to, if the order was going to be passed today, I was going to heave a sigh of relief, given what happened in the previous matter. But very well. Grateful.
My application praying for grant of the probate, my lord. Lord, the son is the executor, my lord. The wife and the mother of the testator predeceased him, my lord. You know, the other legal heirs have given their no objection, my lord. The three daughters and the daughter-in-law and grandson of a predeceased son have given their consent affidavit. My lord, the execution of the will is also duly proved by one of the attesting witness, my lord. You will find that I've given the table, my lord. It is at paragraph 4. You'll appear at page 4, my lord, of my application. Grateful.
The last matter in the list, my lord. I was seeking an opportunity to address your lordship. My lord, the executor is 90 years old. I was praying if your lordship can